ओके, लेट्स स्टार्ट दिस। मेरे पास कोई पीपीटी नहीं है, कोई जादू की छड़ी नहीं है, धीरे धीरे समझते चलेंगे हम। ठीक है, स्टार्ट करते हैं। सबसे पहले हम जब भी हम फैमिली लॉ की बात करते हैं, पीपल आर स्टिल कमिंग। ओके, तो हम जाएंगे पर्सनल लॉ पे। ठीक है, क्योंकि फैमिली लॉ आपको मैं धीरे धीरे हिस्ट्री से लेके चलूंगा, एंड लिटिल बिट ऑफ हिस्ट्री इज इंपॉर्टेंट। मैं आपको डायरेक्टली हिंदू मैरिज एक्ट में लेके जाऊं और चीजों को समझाना स्टार्ट कर दूं, दैट विल बी प्रॉब्लमैटिक थिंग फॉर यू। ओके, तो हम इसका बेस समझते हैं, होता क्या है पर्सनल लॉ, होता क्या है। तो पर्सनल लॉ क्या है? सेट ऑफ लॉज विच गवर्न एंड रेगुलेट रिलेशंस। आप नोट्स बना के चलिएगा, मैं डिक्टेट भी कराऊंगा, आपके पास में कॉपी और पेन होना चाहिए स्पेसिफिकली फॉर दिस क्लास। ओके, rising out of certain factors, connecting two or more persons। सिंपल डेफिनेशन, कोई बहुत ही सेटल्ड डेफिनेशन नहीं है, क्योंकि ये डेफिनेशन जो मैंने पर्सनल लॉ की बताई है, बाकी लॉ पे भी इट विल अप्लाई टू अदर लॉ आल्सो। दिस डेफिनेशन विल मे अप्लाई टू अदर लॉज आल्सो। Okay, so personal law, as I have told you here, is a set of laws which govern and regulate relations riding out of certain factors. We are going to highlight this certain factors connecting two or more persons. So if we talk about Indian Contract Act, then that is also a personal law, but Indian Contract Act is not a personal law. So in order to find out the real definition of personal law, we need to find out those factors. What are those factors? What we talk about these certain factors, कौन कौन से फैक्टर्स होते हैं? लेट्स सी व्हाट आर दोस फैक्टर्स। मैरिज, डाइवोर्स, सेपरेशन, एडॉप्शन, मेंटेनेंस, लेजिटिमेसी, गार्डियनशिप, custody of the child, and succession. These are the factors. Now when you read this definition, what is personal law? Personal law is a set of laws which govern and regulate relations rising out of these factors: marriage, divorce, separation, adoption, maintenance, legitimacy, guardianship, custody of the child, and succession, connecting two or more persons. जैसे मैरिज है, it connects who or person, it connects husband and wife. Divorce, husband and wife. Separation, husband and wife. Adoption, child and father and mother. Maintenance, husband wife, the father and the son. तो ये अगर आप देखेंगे, if you look at these factors, they connect two or more persons. Okay, so this is the basic definition of personal law. Now how it works, let's see. I'm not taking you directly through the acts, bare acts, because this base has to be very strong. Now how you are going to govern personal relations in family setup. जब स्टार्ट हुआ था सब कुछ, जैसे भी हम when we started this race, human race in India, after that the question was asked that there were so many family disputes, not only family disputes but also the outer disputes in relation to the contract, in relation to trade and commerce. Crime was happening, and there was a fight in family also. Husband wanted to separate from wife, wife wanted to separate from husband. So many things were there. So The question was how you are going to govern personal relations and family setup, or how you were going to govern personal relations and family setup. So what happened? They laid down certain norms, okay, and then these norms step by step got these norms in later stage got recognition, or you can say statutory recognition. जो हमें आज what we find in Hindu Marriage Act, what we find in the Hindu Minority and Guardianship Act, Hindu Adoption and Maintenance Act, we'll come that in a later stage. So there were so many problems in the beginning. Okay, now I'm giving you warning, all of you. If I find anyone switching on audio without my permission, I will throw you out directly. Okay, and you will not be getting entry in this because the class gets disturbed. Okay, so earlier the problem was how you are going to govern personal relations and family setup. Certain norms we ourselves laid down certain norms. अब ये जो norms हैं, some norms takes the part of customs. हमने खुद की अपनी customs बनाई, we developed our own customs. We had this religious text. We will go in later stage what are the sources of a Hindu law and Muslim law. Religious text. Now I'm not talking about only Hindu law now. I'm talking about Hindu and Muslim both laws, or any personal law. We have religious text. We had Quran. We had Bhagavad Gita. We had Smritis, Shrutis. We had Dharma Shastras, Vedas. Okay. So we laid down certain norms which were based on religious texts. Some norms were based on customs. Okay, because everything is not depending on the religious text. And some norms from the religious text and some from custom, they got the statutory recognition in later stage. But before that, we need to find out, or the laws which we are going to cover in this session, we need to know this. Hindu law, in British time I'm talking about, Muslim law, and then there were British laws. अब पारसी लॉ, क्रिश्चियन लॉ मैं इसलिए नहीं लिख रहा हूं because they made this law. Britishers made this Parsi law. They passed some Parsi Act in that time. Also Christians and Marriage Act and so on. So we'll go in that in a later stage. So you can write down few points. It's a brief history kind, so that you always remember how it came. Okay, write down. Earlier in ancient times, religion governed everything. So we'll write down and we'll understand. Religion governed everything. All aspects of human life. All aspects of human life क्या होता है everyone? All aspects of human life मतलब it includes marriage, adoption, maintenance. It even includes evidence, criminal law, procedural law, trade and commerce, everything. So earlier, religion used to govern everything. Not only personal law, not only marriage and divorce, but also trade, commerce, crime, everything. Who used to govern? The religion used to govern. अगर किसी को punishment मिलनी होती थी मनुस्मृति के हिसाब से मिलेगी. If someone is going to get some deal with the contract act and something, there were many other shastras. Okay, Hindus used to have their own personal law. Muslim used to have their own personal law to punish people. Okay, to govern their treaty, to govern their contract, to govern their family matters. So for everything there were religious text. For everything there was religious law. Okay. Now all aspects of human life, both public and personal. Write down both public and personal. What is public? In public, you mark an arrow and write crime, evidence, procedure, contract, crime, evidence, procedure, contract, trade and commerce, etc. In personal, you write all those points: marriage, divorce, adoption, maintenance, जो भी हमने the one which we just pointed out just a moment back. So now let's see evolution of personal law in India. Okay. So what was the situation after this disintegration of the Mughal Empire? Britishers came, they built East India Company and so on. They earlier wanted to govern only this commercial side, trade and commerce and all these things they wanted to govern because they were only in relation to the trade and commerce part. They never wanted to govern this religious side earlier. So when they came to India, before that there was Muslim rule. Okay. So now write down when Britishers came to India, there was a Muslim rule which came to an end, which came to an end after disintegration of Mughal Empire. Now in 1726, Britishers brought English law in India. Britishers brought English law in India. There were few mayor court were established under in Madras, Bombay, and Fort Williams. Madras, Bombay, and Fort Williams. In 1726, English law came in India, which established these courts, mayor court in Madras, Bombay, and Fort Williams. Now the problem was to what extent this English law is going to apply to Indians, because the situation was still the situation today. Also, the situation is if you touch the personal law, we all get hyper. Okay. So in that time also, in 1726 also, and 17th and 1880s also, the situation, the question was to what extent this English law is going to apply to Indian. Now, this Britishers thought, if you see, there's a one myth in personal law. We all think that personal laws are very rigid in nature. We all think, right? Hindu law बहुत rigid है, Muslim law is very rigid. Okay, but it's not like that. This was the interpretation which was given by the Britishers. Okay, to some extent the law was rigid, but there were developments also. But Britishers, when they came, they could not understand the personal law because it was so deep. I will tell you that in later stage. So what Britishers used to think, that are all laws are from these customs only, customary practices only. But we had two category of it. We had two category of religious law. One which was based on text, जैसे गीता हो गया, स्मृतिज हो गया, कुरान हो गया, and second was the category of the customs. But they did not bifurcate these two categories, so they mixed it one, and they said that their personal laws are very rigid, and they started giving their interpretation like that. Okay. Now, problem was when the Britishers came, as in 1726 and so on, Muslims used to apply their own law, Hindus used to apply their own law. तो कोर्ट को डिफरेंट इंटरप्रिटेशन देने पड़ते थे, डिफरेंट तरीकों से जाना पड़ता था. ओके, एंड दिस बिकम वेरी प्रॉब्लमैटिक. कैसे बना प्रॉब्लमैटिक? एज आई टोल्ड यू, मुस्लिम्स used to follow their own law, Hindu followed their their own law. English spellings, forgive me for that. So Hindu followed their own law. Now, it became very, very problematic for them. How it became problematic? See, I'll give you the practical situations of this. So, there was a judgment, Gour, you can write, versus Gaur Bulub versus Parsaud, 1834. Now, in this case, judge was Sir Francis Macnaghten. Now, there was in this case, the question was in relation to interpretation of Hindu law. Now, Sir Francis Macnaghten, because they were not knowing a personal law. So, if you do not know the personal law or Hindu law or Muslim law, whom you will consult? You will consult the Pandits. Okay. You will consult one Pandit. Now, the problem, if you go to Haridwar or if you go some other place in India, still today, you will find out one Pandit is saying something else. Another Pandit is saying something else. Third Pandit is giving his own opinion, says both are wrong. Fourth is giving his own wisdom. He's sharing his own wisdom. So there were so many problems. Now, Sir Francis Macnaghten got frustrated with this. He consulted 51 Pandits. I'm just telling you that how complicated the family law is. You all think that it's easy. It's not. It's not complicated. Sir Francis Macnaghten. When you will study the legal history part, you will all come to know who is this Sir Macnaghten. So Sir Francis Macnaghten in this case had to consult 51 Pandits. Okay. So I'm giving you this judgment to make you understand that how it is developing. Okay, why the statutory recognition was required and why it was not. So Muslim used to follow their own law, as I told you. Hindu used to follow their own law. It became very problematic for the judges because they had to go and read themselves. They have to read all these this Dharam Shastra and text. There was another judgment I would like to give. This is one. Write down the second. I'm not giving you the findings of those judgments. I'm just giving you this so as to make you understand the difficulties in understanding the family law. Doe Dan, Munnol versus Gopi Dutti. This is 1786. In this also, there were different opinions. One Pandit said something, another said something else. Then there was Justice James in this. He had to first learn Sanskrit, then he read religious text himself. उन्होंने बोला कि ठीक है पंडित जी आप रहने दीजिए, we ourselves will go through this. So he himself went through all the religious text and came to the conclusion. So it was complicated. There was no static things. There was no constant thing that everyone is saying the same thing. Like now, in today's context, suppose if I talk about divorce, you all know cruelty is a ground for divorce, right? Now, earlier time, Pandit used to say, no, cruelty is not. Another Pandit saying cruelty is. One Pandit said, no, only desertion is. Another saying, no, desertion is not. So there were so many problems. So the judges themselves had to go through the entire religious text. They had to learn Sanskrit. and everything. So the situations were very, very problematic. So the situations were not different even for the Muslim law. Okay. Problem in Mohammedan law was also same. It was also very much complicated. Okay. Why Muslim law was problematic that time? Because in India, there are two kinds of Muslim, Shias and Sunni. अब इनके में problem क्या था? These judges, they said, okay, we are ready to study this Shia's law. Fine, we are going to give the interpretation. Now again, when we are dealing with the cases of Sunni, to what extent this Shia's law is going to be applicable for the Sunnis people? So again, it became problematic because there were two sects. Shia used to say that I'm not going to follow Sunni law. Sunni used to say we are not going to follow the Shia law. Okay. So the question was here whether Shias were entitled to their own laws or they were to be governed by the doctrine of Sunni school. This was the question. Okay. तो बहुत दिनों से इनकी लड़ाई चल रही थी. The problem was never clear. Okay. क्यों problem clear नहीं था? The problem was not clear because there was in relation to Muslim laws interpretation, Warren Hastings in 1772. In relation to the interpretation of Mohammedan law, there were two words used. They said Muslim law or Mohammedan law is the law of Quran. First thing he used. And second thing he used, it's known as Mohammedan law. Okay. इसके अलावा there was no difference. There was no different Shia law, Sunni law, nothing was there. So law of Quran or Mohammedan law. So because of this, these judges again started getting problem whether they should apply Sunni law, whether they should apply Shia law. Okay, because the things were not clear. In later stage, there was a judgment. It's very famous judgment, Raja Didar case. Hussain versus Raini, Zuhouran, Zahuran Nisha, 1841. It was Privy Council's decision, PC's decision. They held that Shias are entitled to their own Shia law. Why? Because that time they never wanted these communal problems to arise. Because they knew that people are very, very much sensitive for their religion, for their personal law. So they do not want to touch it. So they played it very naturally. They said, okay, Shias are also entitled to their own Shia law. Okay. Now, as I told you, in 1841, judges were playing very safe. The foreigners, the Britishers were playing very safe. So what happened after that? They said, okay, we will go step by step. Immediately, we will not affect the personal law. Okay. So they played it very safe. In 1860, they did not touch the family matters. जैसे in today's context also, हम लोग सब लोग रहते हैं साथ में, हमारे घर के बारे में कोई बीच में पढ़ता है, if someone is outside interrupting in our family home, what we say, हमारे family matter में मत पढ़िए आप. So everyone was very sensitive for the family matters. That time also everyone was very sensitive for the family matter. Even today we do not want to go for the uniform civil code. Okay. Hindus also say that they will go for the uniform civil code, but the time it will come, there will be problems. So Britishers knew it very properly that the people are very sensitive for this. So what they did, as I made you right in the beginning, there were two type of affairs, public affairs and personal affairs. So the Britishers did not touch the personal affairs of Hindu and Muslims. They definitely touched Christians, but they did not touch Hindu and Muslims personal law, the family matters law, which used to govern the personal affairs. So in 1860, 1872, आपको पता है ना कौन से एक्ट आए थे? They got Indian Penal Code. 1862, right? 1860. They got Indian Evidence Act. They got Indian Contract Act. Indian Penal Code कब आया था? 1860 around, right? Indian Evidence Act
1872.
1872. Indian Contract Act same 1872. So we can find out here they were not touching the personal law which used to govern the family matters. They started touching the public affairs matter. They said, okay, fine, we are not going to interfere with your family matters, but let's see, for everything we cannot use your personal law. Suppose if there is a fight between Hindu and Muslim, and Hindu has beaten Muslim or Muslim has beaten Hindu, whose laws are going to apply to give the punishment? It was very problematic, right? Muslims or Hindus. So they said, okay, we will be governed by Indian Penal Code, we will be governed by Indian Evidence Act, Indian Contract Act. Forgive me for the spellings. Okay. So these were the secular laws. They used to have the applicability for all the religions, Hindu, Muslim, Christians. Okay. Now with this, they brought, since they were knowing the sensitivity of Hindu and Muslims, they did not touch it. But at the same time, to give effect to touch the family affairs, they brought Divorce Act 1869. They brought Christian Marriage Act 1872. They brought Parsi Marriage and Divorce Act 1936. It came in later stage, but still I'm mentioning this. So these are the acts which they brought. Why? Because at one side they did not want to touch the personal law of Hindu and Muslims, but at the same time they wanted to instill in the minds of Hindu and Muslims also that someday, sooner or later, we will be bringing personal law for you also. But we are starting from the Christians. We are starting from the Parsis, whom they were knowing that they are not going to agitate. Okay. So for everyone, they got Indian Penal Code, evidence, contract, and so many things for procedural laws. Even CRPC also came. Now the question was in relation to the CPC, the Code of Civil Procedure. They did not get the Code of Civil Procedure then, because Code of Civil Procedure merely talks about the procedure, but in substantive way, what laws is going to be applicable, whether personal law of Hindu and Muslims or all only the secular laws. So CPC, which came in 1908, उन्होंने बोला कि ठीक है, we are not touching the Muslims and Hindus and Muslims personal law, but fine, CPC will govern even the personal law side also, but CPC is only touching the procedural part of it. So they played it again very nicely. They brought the procedure and they said, okay, we are not touching your substantive personal laws, but you go by this procedure, because for the judges, procedures are going to be very different. Now, one more thing happened. There were people who say, no, we are not going to be governed by this common secular civil procedure code. So when they brought this law, when the Hindu and Muslims, all these people used to go to court, there was no hearings for them. Why there were no hearings? Because the cases were not going to be entertained by the court, because they used to say that we are not going to be governed by the CPC, we are not going to be governed by this secular procedural law. So step by step, this agitation for the procedural laws went down, and the people started applying this CPC. So you need to understand that how it is going, how Britishers played with this. Hindu law, then Muslim, Shia, Sunni, how the questions came, okay, then judgments came, they sort out some problems, then the secular law came, then they first affected the personal laws of Christians and Parsis, and then CPC they applied for everyone. Okay. After that, so with regard to CPC, they had very cautious approach. Okay. because they knew that communal tension will rise and people will think that this is a displacement of their religion. और इंडिया में अगर religion की बात करोगे तो then they can throw anyone out. So they were very cautious with this. After that, now there were other sects. हिंदू एंड मुस्लिम्स के अलावा भी अदर थे, बहुत सारे लोग थे. कौन कौन थे अपार्ट फ्रॉम हिंदू एंड मुस्लिम? सिख्स, जैन, बुद्ध. मुस्लिम में कौन थे? हु वर दे द पार्ट ऑफ मुस्लिम्स? शिया and Sunni. So these Britishers considered from the beginning itself, Sikh, Jain, Buddhist, they always believed that in India there are only two categories, Hindu and Muslim. And then Christian Parsi they used to consider under British only. So they used to think that in India Hindus are, Sikhs are also Hindu, Jain are also Hindu, Buddha, जो है Buddhist religion who follow Buddhist religion, they are also Hindu. Okay. So this is how it came, and after that the laws started coming. I'm not going to go to teach you the deep history of it. Okay. So this is it. I wanted to give you the brief understanding that how it started coming. कि कैसे आपके personal laws आना धीरे धीरे start हुआ. How it started coming. Okay. Now, if I start telling you the deep history of it, again you all will get bored and this will be your last class. So I'm not going to do that. Okay. Now come to the practical aspect of it. What is the practical aspect of it? Because many students have this in mind, sir, you are teaching history, it's not going to come for judicial exam, we are not going to use in litigation. Okay, but it's very important to understand the base, that how it came and all, the origination of it, the history of it. Let's go to practical aspect of it. There are many statutes now. As I told you, these customs, these religious texts, all these personal laws, this after some time, which we used to know as the norms, they got these statutory recognitions. Okay. And then there were many statutes which came after that. Many statutes. So we are going to today know the different kinds of statute which govern the personal law. And we are just in simple way, we are going to understand that that particular statute deals with what. There are so many advocates also, I'm telling you, I'm not kidding. When I put forth before them the list of acts, suppose if I tell that Hindu Disposition of Property Act, people say, huh? It deals with what? If I tell you Hindu Succession Act and Indian Succession Act, it deals with what? You will again say, we are not able to distinguish. If I tell you that this Hindu Minority and Guardianship Act and Guardianship and Wards Act, both the acts are different, but people think that they are same, they are dealing with the same things. So what is the difference among all these statutes? So if we have come to know about this exercise today, the list of statutes, these statutes deals with what? Suppose if someone is asking you Hindu Adoption and Maintenance Act, it deals with what all things? What are the personal laws things that this act deals with? You should know about it, right? Because you have taken the first class. You should not only confine yourself to the history part. So we are going to this. So let's go to first Hindu law. Hindu law. So in Hindu law, first act, Hindu Marriage Act 1955. It deals with what? Everyone knows that. If someone is in third year, final year, everyone knows that it deals with marriage, separation, it deals with divorce, it also deals with maintenance. ऐसा नहीं कि maintenance deal नहीं करता है, maintenance भी deal करता है. Okay. What is that second act? So Hindu Marriage Act, we never get problem. Second act is Hindu Succession Act 1956 on one side, and third we are going to have Indian Succession Act. I have seen people who have studied family law completely in their college. They are not able to tell me the difference Hindu Succession Act deals with and Indian Succession Act deals with. क्योंकि अब कॉलेज में तो हम सीधे फटाफट फटाफट होता है ना, teachers are also bound to complete the syllabus. So there are many problems. So Hindu Succession Act and Indian Succession Act 1925. So Indian Succession Act deals with two kinds of succession. What is that? Testamentary succession. First, you need to understand what is the meaning of succession. Succession is, if I have any property, it's going to go to whom? My son, my wife, my daughter. That's called succession. For now, in a simple language. Okay. So there are two kinds of succession: testamentary and
Intestate.
intestate. Testamentary मतलब intestate मतलब dying without will. Yes. Someone is saying something?
ऑलरेडी विल डिसाइड है टेस्टामेंट्री में तो, और इंटेस्ट में विल नहीं बनाई और डेथ हो गई है उस पर्सन की.
करेक्ट करेक्ट. सो इंटेस्टेट में मतलब डेथ हो गई है बिना विल बनाए, बिना किसी को गिफ्ट किए. दैट्स कॉल्ड इंटेस्टेट. विदाउट विल, विदाउट गिविंग एनीवन एज अ गिफ्ट. टेस्टामेंट्री इज without will. Testamentary is with will.
With will.
Yeah, with will. Okay, for now, for a short understanding for now. So Indian Succession Act deals with testamentary and intestate both. Now let's go to this. It deals with what? It only deals with intestate succession. Now the question is, Indian Succession Act is also dealing with the intestate succession. Hindu Succession Act was also dealing with the intestate succession. Then which law is going to apply? So the answer is, for Hindus, for intestate succession, Hindu succession is going to apply. And for testamentary succession, for Hindus, Indian Succession Act is going to apply. Understood this much?
Please repeat once.
I'll repeat. So I'm writing here, for Hindu, since Indian Succession Act has come in existence, Hindu Succession Act has come in existence. Hindu Succession Act also deals with intestate succession. Hindu Succession Act has one section in it which says that for the intestate succession of the Hindus, Indian Succession Act will not apply. So for Hindu, for intestate succession, what law will apply? Hindu Succession Act. For Hindu, testamentary succession, what law will apply? Indian Succession Act. I hope I have made myself clear. Understood everyone? तो क्योंकि in order to deal with the intestate succession, intestate मतलब without will, we have now our own personal law. We have now, Hindus have their own personal law. Same as with the Muslim, we will come to that later stage. So Hindus have their own personal law. For intestate succession means Indian Succession Act will deal with it. For testamentary succession, Hindus have no law. So Indian Succession Act will deal with it. Indian Succession Act deals with both testamentary and intestate. But for Hindus, only testamentary. With regard to will, what are the provisions for will? How many witnesses should be there and all that it deals with. Okay. Now, अब आप बोलोगे सर for Christian, for both testamentary, testa and intestate, Indian Succession Act will apply. Okay, so succession of Christians is dealt under Indian Succession Act, because they do not have their own personal law with regard to the succession of testamentary or intestate either. So if for any religion they do not have their own personal law, Indian Succession Act will apply in relation to the succession for both. Now for Muslims, Muslims have their own personal law. They have Quran, they have other sources such as succession is dealt under Hidayah, or it's called Fatwa Atamgiri. Fatwa Atamgiri. We will learn all these terms when we will go in that stage to learn the Muslim law. So Indian Succession Act has no applicability for the Muslim laws. Okay. Now for Jain, Sikh, Buddha, for all that, same as Hindus. Okay, because they have been considering as Hindu from the beginning. They have been people used to consider them Hindu from the beginning itself. Jain, Sikh and Buddha. तो उनका लिए same provision है. मतलब what is
So
that
sorry
for
to
test?
interrupt you, sir. So
Yeah,
sorry
please
to
tell me.
interrupt you, sir.
Yeah, please.
If you are writing something, I am not able to see because the screen is not visible downside. If you could scroll
Okay.
it down or zoom out a bit.
Just a minute. Is that fine now?
Yes, sir. Thank you so much.
Oh, okay, no problem. Okay.
Excuse me, sir.
Yes.
So sorry to disturb you. Can I ask a question?
Yeah, please ask.
Sir, as we see in this particular, when you were discussing about Hindu Succession Act and Indian Succession Act,
Yes.
in Indian Succession Act, both the testamentary and the intestate
Correct.
parts been dealt, and in the Hindu succession part, only intestate succession has been dealt. So
Correct.
there has been a conflict between two legislation as we see here.
No, there is no conflict because Hindu Succession Act, specific provisions of this section 3 or something which specifically mentions that in relation to intestate succession, Hindu Succession Act will apply for Hindus. So there is no conflict.
But sir, in Indian Succession Act, the interstate provision is also inserted.
There's no problem. So for intestate, that's see, this is only the point. यही तो complications है in personal law का.
So sir, which is the competent? Is it the judiciary
No,
which
no.
is the competent authority to decide that which particular
No,
legislation applies?
no. I'll tell you. See, you need to understand this. When there are two legislations, whenever there's a conflict, first thing, there is no conflict. Why there is no conflict? There is no conflict because in relation to intestate, see, I'll tell you, in 1925, Indian Succession Act came. Indian Succession Act came and it used to deal with both testamentary and intestate, both. Okay. But when we adopted our own constitution, when the constitution was passed, and after that, there were many laws which came in force. So for Hindus and for succession, let me tell you, succession and adoption, only this major religion has the law. Okay. So for succession, there was demand. So Parliament passed this law that in relation to intestate succession, fine, Hindu Succession Act, which we are passing now, will be applicable for Hindus. Okay. To the extent of intestate succession, Hindu Succession Act will not apply for the Hindus. That is it. Testamentary will apply. There is no problem. So in Hindu Succession Act itself made it clear in 1956 that in relation to intestate succession, court does not have to go for Indian Succession Act. For Hindus only. For Hindus only. Simple.
Okay, sir. Thank you. Thank you so much.
Okay. Yeah. So Hindu Succession Act deals with intestate succession only for Hindus and not for any other religion. Indian Succession Act deals with everything. So you need to remember, Indian Succession Act will apply in relation to testamentary and in relation to intestate only to the extent of personal law not being there for that particular religion. If personal law for any particular religion is there which governs with testamentary and intestate, Indian Succession Act has no applicability. As simple as that. So for Hindus, intestate succession, Hindu law is there, Hindu Succession Act is there. So for intestate succession, Indian Succession Act is not going to apply. Understood? Is there anyone who is having problem with this, or it's sorted? भाग्यश्री समझ आया आपको?
Yes, sir.
Okay, fine. Okay, Karan Mathur, I will use Hindi, English both. So I will repeat that in English also. Okay? तो मैं केवल ये कहने की कोशिश कर रहा हूं आपसे, एक बार लास्ट बार ट्राई मारते हैं सबके लिए. इंडियन सक्सेशन एक्ट टेस्टामेंट्री एंड इंटरस्टेट के लिए तब तक एप्लीकेबल होगा जब तक उन पर्टिकुलर चीज के लिए कोई पर्सनल लॉ नहीं है. तो हिंदूज के लिए इंटरस्टेट सक्सेशन के लिए क्योंकि पर्सनल लॉ है, इसलिए इंडियन सक्सेशन एक्ट will not apply in relation to intestate succession for Hindus. That's it. Muslims के भी they have their own personal law for both testamentary and intestate. So Indian Succession Act will not apply to Muslims also because they have their own personal law. For Christians, they do not have any personal law. So Indian Succession Act will apply for both testamentary and intestate. Jain, Sikh, both they come under Hindu. So Hindu have their own personal law in relation to intestate succession. Simple. Okay. Everyone is able to understand this? Pakka? Okay, moving ahead with the next statute. So हमें जब when we are going to start this Hindu law, Muslim law, we should know these statutes that it deals with what. Otherwise, we will be confining ourselves to the Hindu Marriage Act itself. Okay? हमें पता होगा बाकी चीजें क्या हैं, but in detail we need to know this. Next act is the Hindu Minority and Guardianship Act. It has total, it has come in 1956. It has total 13 sections. And the another act is, this is fourth one, right? Guardianship and Wards Act 1890. Now see, Guardianship and Wards Act came in 1890. The time this Indian contract and all that came. Because it was a secular law. Guardianship and Ward Act is a secular law. It's not confining to one particular religion. And people get confused with these two statutes also, that Hindu Minority and Guardianship Act कब अप्लाई होता है. There are so many people who have asked me कि सर ये Guardianship and ये Minority Act कब अप्लाई होता है and ये Guardianship and Wards Act कब अप्लाई होता है. So what is, there's a question in relation to its applicability, in relation to their applicability. When does it apply? So Hindu Minority and Guardianship Act apply, as you can see, only for Hindus. But for Hindu, this also apply to Hindu also because it's secular law. So it also apply to Hindus. So only for Hindus. Now, सबसे पहले ये समझने की जरूरत है कि हिंदू माइनॉरिटी एंड गार्डियनशिप एक्ट डील किस चीज से करता है. हिंदू से तो डील करता है, दैट्स फाइन, बट इन रिलेशन टू व्हाट. तो पहली चीज हमें इसमें जो नोट डाउन करनी है वो है दैट इट इज अ सब्सटेंटिव लॉ. It's a substantive law to deal with the custody and guardianship of child. When I say substantive law, what is the meaning of substantive law here? कई लोग फर्स्ट ईयर में हैं, हो सकता है ना पता हो सब्सटेंटिव लॉ एंड प्रोसीजरल लॉ का मतलब, ऐसे
Sir,
क्लैट में जब
which
तैयारी
tells,
करते
sir,
yes
which
yes
tells about the our rights and liabilities.
great so which talks about the rights and liabilities, right? So substantive law, it is a substantive law to deal with custody and guardianship of child. What is that meaning? It means whenever the court will deal with the guardianship of Hindus and custody of Hindus, they have to take into consideration the principles, the provisions of Hindu Minority and Guardianship Act. What are those principles? What are these things that court need to take care of? First is कि भैया guardian कौन होगा? Who will be natural guardian? Deals under what? Hindu Minority and Guardianship Act. Who will have the custody of child? Deals under where? Hindu Minority and Guardianship Act. What are the factors court will take into consideration to decide custody or guardianship? कौन से फैक्टर्स होते हैं? It's called ultimate principle is welfare of the child, which deals with section 13 of the Hindu Minority and Guardianship Act. Anyway, we will go to that extent in a later stage जब हम पढ़ेंगे उसको डिटेल में, ठीक है? अब हम चलते हैं गार्डियनशिप एंड वार्ड्स एक्ट में. गार्डियनशिप एंड वार्ड्स एक्ट इज एक्चुअली अ procedural law for all religion, चाहे वो हिंदू हो, मुस्लिम हो, क्रिश्चियंस हो, फॉर एवरीवन. ओके, क्या बताता है? दिस टेल्स द पावर ऑफ कोर्ट, jurisdiction of court. Now Hindu Minority and Guardianship Act does not deal with all that. So for Hindus, whenever you talk about custody of the child or the guardianship of the child, suppose एक माँ है, एक माँ अपने बच्चे से अलग हो गई है, या एक पिता अपने बच्चे से अलग हो गया, he will file immediately a custody petition or guardianship petition before the family court. ओके, फैमिली जज डील करते हैं इसको, प्रिंसिपल जज जो होते हैं फैमिली कोर्ट के, या दूसरे जो जजेस होते हैं फैमिली कोर्ट के, वो डील करते हैं. It will immediately go to the family court. Family court will apply the principles, the sections laid down in Hindu Minority and Guardianship Act, but the power, the jurisdiction they will get from the Guardianship and Wards Act. So it does not mean that for Hindus, Guardianship and Wards Act is not going to apply. It will apply because it's a secular law. It applies to all the religions. Understood? So power of the court, territorial jurisdiction of the court. Now suppose if you are in Delhi, the child is in Mayur Vihar phase 1, where I live, and I'm going to file a case in the Tis Hazari court. It's quite far from here. The question is, किस कोर्ट के पास में jurisdiction होगा? Now Hindu Minority and Guardianship Act does not deal with it. अब जो नए बच्चे होते हैं वो फटाफट हिंदू माइनॉरिटी गार्डियनशिप एक्ट खोजते रहते हैं कि सर पावर ऑफ द कोर्ट दिया कहाँ है, कौन सा कोर्ट डील करेगा. You have to go and find out in Guardianship and Wards Act, section 6, 7, 8, 9, they all deal with that. Okay, understood? So it has 53 sections. Total 53 sections. So now we have understood the 5 statutes, right? रट लो, दिमाग में एकदम डाल लो इसको. हिंदू मैरिज एक्ट, सेकंड इंस्टीट्यूट कौन था? हिंदू सक्सेशन एक्ट. थर्ड कौन था? इंडियन सक्सेशन एक्ट. फोर्थ हिंदू माइनॉरिटी एंड गार्डियनशिप एक्ट. फिफ्थ गार्डियनशिप एंड वार्ड्स एक्ट. एकदम मतलब सोते से भी कोई उठाए तो आपको याद आना चाहिए. यस मिस्टर आर, यू हैव एनी डाउट? टेल मी.
Sir, this is the Guardianship and Wards Act is the procedural law for everything,
All
or
the
is
religion.
or
For
is
all
that the
the-
procedural law for minority and guardianship?
No, obviously it is a procedural law only in relation to decide the custody of guardianship and custody. That is it.
All right, thank you.
In relation to, see, in relation to succession, we have different law. In relation to marriage, we have different law.
All right,
Okay.
all right, got it, sir. Thank you.
Yeah, the name of the statute itself tells you the that for what purpose it is going to come, or it is there. Okay, so Guardianship and Wards Act, obviously in relation to guardianship and wards, to decide the custody, decide the guardianship. Moving to the next act, the Hindu Adoption and Maintenance Act 1956, 30 sections. Just a minute. Just give me a minute. Okay. Hindu Adoption and Maintenance Act. Now this deals with, what are the things that this act deals with? इसके साथ जब भी हम पढ़ेंगे, we have to go through the amendment of 2005. Very very important for judicial service examination. जब से ये 2005 का एक्ट आया है, सारे स्टेट में इसी के क्वेश्चंस आते हैं, because sorry, there was an amendment in 2010, not in 2005. So this amendment we need to go through. इसमें क्या अमेंडमेंट किए थे? पहले क्या सिस्टम था कि जो वाइफ होती थी, द wife was not having any power to adopt the child. Now the wife has also got the power to adopt the child. Only earlier the husband used to get the child. Husband only has the power to adopt the child. Now even if the husband is there, the wife can adopt the child with the permission of the husband, with the after having the consultation with the husband. We will go through all these procedures. We will also talk about whether it's a discriminatory in nature or not, because it's a personal law. There is the court is very reluctant to challenge the constitutional validity of all these things, but we will deal with this everything in detail. Okay, so we will go through this amendment of 2010. It deals with one requisite of valid adoption. अब आप लोगों ने देखा होगा हमारे गांव में, जैसे जिस किसी का बच्चा नहीं होता है, the person who do not have any child, the parents who do not have any child, husband and wife, they earlier used to go to village, in an Adivasi village, in the scheduled tribe places. In scheduled tribes, someone has having 5 to 6 child, then they used to take one child from him after paying some 500 and 1000 and 2000 rupees. This is the this was the system. Even today there are places in India where they sell their child in 200 and 500 rupees. Even today, you will not believe this. There was a United Nations report for this. So this law had to come, that you cannot simply adopt the child. Now what people used to do, they used to adopt the child. Please switch off your audio. I will take your doubts later stage if you have any. So people used to adopt the child, and when they are not able to take care of them, they used to just leave somewhere. So now all the laws, earlier all the laws were parents centric. The rights of the parents were very important. Suppose if you're talking about Minority and Guardianship Act, if you're talking about Hindu Minority Guardianship Act and all the other acts in relation to guardianship and child, पहले क्या jurisprudence था? पहले jurisprudence था कि माँ का अधिकार है बच्चे पे. पहले ये jurisprudence था कि पिता का अधिकार है बच्चे पे. The father has right over the child. The mother has right over the child. Now the jurisprudence has changed. Now what are the principles? Now the principle is welfare of the child will be ultimate paramount consideration. If the child is with the mother, but if mother is not able to bring up the child in a proper way, the child will be shifted from mother to the father. The same situation lies for the father also. तो पहले jurisprudence क्या था? पहले jurisprudence था parents centric. अब laws कैसी बन रही हैं? Child centric. Okay? पहले adopt कर लेते थे बच्चे को, they used to live anywhere. Now they have to make sure that they are going to maintain the child properly, even the adopted child. So you remember this, that now all the laws which are being drafted, which have been passed, the Supreme Court, the laws which Supreme Court is dealing with, they are all child-centric laws. So requisite of valid adoption, there are ceremonies, there are many things which the parents have to follow. It's not so simple that you go there and you just adopt the child. There are some limits also in adoption of the child. You cannot adopt more than 2 and 3 child. The laws are there for that also. Okay. Now, second thing, it deals with capacity of female Hindu to adopt. This came in 2010 amendment. Okay, we will deal with it in later stage. Okay, now person capable of giving up adoption. What is that meaning of this? Who are the persons who are capable of giving adoption? As I told you earlier, anyone scheduled tribes, they the people used to go and they used to give the child to them. But now even their capacity will also be taken into consideration. Not only financial capacity, but whether they are sound mind, whether they have enough resources, and there are many other things. We will go that in detail in later stage. Okay. This is the third point it deals with. Now, when we talk about this Hindu Adoption and Maintenance Act, हमारे दिमाग में एक चीज चलती है कि ये केवल बात करता है बच्चों के अडॉप्शन की और बच्चों के मेंटेनेंस की, बट ऐसा नहीं है. It has a larger scope. It also talk about the maintenance. किसके किसकी मेंटेनेंस की बात करता है? It deals with wife's maintenance. Section 18. Okay, so wife, generally जब हम family law पढ़ते हैं, we all have this in our mind. Not all, many of us have this in our mind, that maintenance of wife is only given under section 125 CRPC or under Domestic Violence Act. No, there are many maintenance provisions. Maintenance to the wife can also be given under Hindu Marriage Act. Maintenance to the wife can also be given under section 125 CRPC. Maintenance to wife can also be given under Hindu Adoption and Maintenance Act. Okay, it can also be given under Domestic Violence Act, interim maintenance, protection of women from Domestic Violence Act. तो ये maintenance of wife के different provisions क्यों बनाए गए? Again, we will deal with that in a later stage, but let me give you this in a short. पहले क्या होता था? People, see, everyone knew this कि कोर्ट में कोई वाइफ जाएगी तो पैसा खर्चा होगा, है ना? पैसा खर्चा तो होता ही है. अब पहले ऐसा रहता था, वाइफ यूज्ड टू बी कंसीडर्ड एज अ प्रॉपर्टी ऑफ द हस्बैंड. वाइफ के पास बहुत ज्यादा पैसे तो होते नहीं थे जाने के लिए डिफरेंट कोर्ट्स में कि ये भी प्रोसीडिंग चला रहे हैं और वो भी प्रोसीडिंग चला रहे हैं. सो द सिचुएशन वाज, सपोज इफ any proceeding is going on in the court, suppose if husband has filed the proceeding for divorce against the wife under Hindu Marriage Act, that my wife has done cruelty against me or my wife has deserted me 2 years before, now I want divorce. So under Hindu Marriage Act also, wife was given a chance to take maintenance. Under Hindu Marriage Act, even husband also have a right to get maintenance from the wife. Do you know that? Husband can also get maintenance from the wife. If husband is not earning, wife is earning, husband can apply for maintenance from the wife under only Hindu Marriage Act, not under this Hindu Adoption Act or section 125 CRPC. So under Hindu Marriage Act, this has the provision. So suppose if some case has been filed for adoption or for any other thing under this particular act, under Hindu Adoption and Maintenance Act, so there is a provision for maintenance to the wife. So for all the separate act, provision for maintenance to the wife and for other persons were maintained. Now for maintenance to the wife is also there under this act. Widowed daughter-in-law, section 19. Maintenance to widowed daughter-in-law, maintenance to children and parents, section 20. Maintenance to dependents, section 22. There are many other provisions. We will deal with those sections in later stage. Now for children, and even section 125 CRPC also deal with this. Maintenance to parents, only there is a now act called Maintenance of Parents and Senior Citizen Act 2005. They also take the they can also take the maintenance from there. So you just need to find out when you deal with the family matters, how many statutes are there. There are many statutes, right? तो उनकी applicability हमें पता होनी चाहिए. Okay? So Hindu Adoption and Maintenance Act deals with these propositions, these factors, these points. There are many other. We'll study in detail later stage. Now, let's go to next statute. 7. This act is very small. The Hindu Disposition of Property Act 1956. Anyone knows? Is there anyone who knows that this act is for what? Hindu Disposition of Property Act. Now you will say, sir, Succession Act तो है ना, इसकी क्या जरूरत है? Hindu Disposition of Property Act की अब क्या जरूरत पड़ गई थी? So the problem was earlier, if suppose I want to gift anything to my unborn child, it's called inter vivos. Inter vivos or by will. Inter vivos is called by agreement, by will. If I want to gift something to someone who does not exist that day. Earlier it was void. Now, through this act, it is valid. Simple. It has very less sections. Only 5 sections are there.
Sir, there is similar provision in TOPA also, na? Vested interest.
Where?
In TOPA.
TOPA is a Transfer of Property Act.
Vested interest. Yes, sir.
Yeah, it's there. But the problem was, in Transfer of Property Act, you have to transfer the property to someone who exists that day. There is a provision for.
We have to create a trust or the trustee.
Yes, correct.
Yes.
So there is a different. But suppose if I want to gift anything or if I want to make will for my unborn child, there was no provision for that. See, Hindu Disposition of Property Act 1956 made it clear that okay, now you can do that. Okay, we will also try to link the provisions which you said, transfer to unborn child. There is a provision in TOPA also. We'll go to that in later stage. Okay, so now through this act it is valid. So the applicability of this act is only confining to gift something or inter vivos transfer or transfer by will to someone who does not exist. For that, Indian Succession Act will apply only in relation to the extent of procedure. Suppose if you are making will for your unborn child, okay, you also need to understand this. Indian Succession Act talked about what? Testamentary successions. There is a provision for will, section 63, for example. It says 2 witnesses has to be there in will. Now, I'm making a will under Hindu Disposition of Property Act. Can you say that in the court that I'm not going to have any witness because I'm making this will for the unborn child, so Indian Succession Act will not apply? Can I say that in the court? No. Because Indian Succession Act deals with the procedural part of it. Hindu Disposition of Property Act does not deal with the procedure aspect of it. It just gives you right that now you can give your will, now you can make your gift for someone who does not exist. It does not mean that you don't have to follow the procedure given under Indian Succession Act or the requisites which are given under the Transfer of Property Act. Suppose if you are giving anything through gift or requisite under Indian Succession Act. Okay, so Indian Succession Act will apply procedural part के लिए कितने witness होंगे, register होना चाहिए, नहीं होना चाहिए. Transfer of Property Act will apply कि register होना चाहिए, कि कैसे दे सकते हैं, writing में होना चाहिए, and many other things. Okay, so it just gives you power that you can, okay, now you can do that, but you have to follow the other provisions. That is why it has only limited provisions, 5 sections. Is there anyone who got any doubt in this? Hi Utkarsh, how are you? रक्षा, कोई डाउट है इनमें अभी? अब अगर कोई ये एक्स पूछेगा तो आप बता सकते हैं?
Yes,
अभी
sir.
तक पता अभी तक पता
Yes.
था आपको ये अभी तक पता था आपको ये एक्ट किस किस चीज में डील करते हैं? रक्षा नहीं पता? उत्कर्ष आपको पता था?
Yes, sir, most of the doubts get clear. मतलब ये हिंदू minorities and guardian, that was very, मतलब मुझे तो थोड़ा अजीब लगा. मुझे लगा कि ये guardianship adoption all will deal with this Hindu guardianship act.
ओके होता
Yes.
है ये प्रॉब्लम, मतलब 95% लोगों को ये प्रॉब्लम्स होती है इन ऑर्डर टू अंडरस्टैंड कि ये एक्ट किन किन चीजों से डील करते हैं. ठीक है, तो जब भी एक पिक्चर आपके सामने आएगी इन एक्ट्स की तो एकदम भूत जैसा, यू विल नॉट रिएक्ट लाइक घोस्ट हैज कम. सो you know that it deals with what applicability इन सब एक्ट्स की कहां पर है, क्या है. So you will find the family law easier now. मैं जब भी आपको पढ़ाऊंगा, whenever I teach you marriage, divorce or something, I'm not going to take you through the bare acts कि section 2, 3, 4, 5, we are not going to go like this. Otherwise family law, in order to cover the syllabus it will take an year. It will take at least a year. तो मैं आपको टॉपिक वाइज पढ़ाऊंगा जो भी इंपॉर्टेंट चीजें हैं. सपोज the factors which I told you, okay, suppose marriage we are dealing with, now we are dealing with legitimacy, now we are dealing with divorce, now we are dealing with succession for Hindus, now we are dealing with adoption for Hindus. On that basis we will understand the sections of the relevant act. तो उसको समझने के लिए आपको इसका समझना जरूरी था कि कौन कौन से एक्ट हैं जो इन सब चीजों को डील करते हैं. अंडरस्टूड? ओके, लेट्स गो टू नाउ मुस्लिम लॉज. ये तो हो गए हिंदूज के. Or family law is very, very important for judicial service examination. Very important. So in Muslims, we have Muslim personal laws, Shariat Application Act 1937. Muslim Personal Laws, Shariat Application Act 1937. It deals with the marriage, succession, inheritance, and charity among Muslims. Okay. Total, it has 6 sections. अब आप बोलेंगे सर 6 sections में हम लोग इतना सारा सब कुछ कैसे डील करेंगे? तो ये केवल प्रोसीजर प्रोवाइड करता है. Substantively, you suppose if you are talking about succession or something, adoption or something, you have to go to Hidayah. जो मैंने आपको चीजें लिखवाई थी, Quran, for something they have, for all these things we have our own dharma shastras. We have our own Quran, Hidayah, and so on. We will go to that in order to find out the substantive part of it. But procedural part of it is given here. Now, there's a second act is called Dissolution of Muslim Marriage Act 1939. It deals with divorce. So marriage is dealt under Muslim Personal Law Shariat Application Act. Divorce is dealt with Dissolution of Muslim Marriage Act 1939. Divorce. Right of Muslim women for residence and all other things. Now you need to remember this act will not apply in Goa, or any of the personal law will not apply to Goa, because in Goa they have uniform civil code. Okay, so all these personal law will not apply there. Or anyone who has married under Special Marriage Act, these law will not apply to them also. 1954. Now the third is Waqf Act 1954. To improve the administrative practice with regard to Waqf. So we have Waqf Act now. Now let's go to Christians, though we are not going to study this Christian personal law, but understand this. For marriage, they have Indian Christian Marriage Act 1872. हम नहीं पढ़ेंगे डिटेल में, बट हमें पता होना चाहिए थोड़ी थोड़ी सी चीजें. Guardianship dealt under Guardianship and Wards Act 1890. Succession, Indian Succession Act हम पढ़ चुके हैं. अभी के क्रिश्चियंस कैसे डील होते हैं इसमें, फॉर बोथ टेस्टामेंट्री एंड नॉन टेस्टामेंट्री. ठीक है. Divorce, they have that Indian Divorce Act 1869. In this page itself, let's understand for Parsis. ये भी हम नहीं पढ़ेंगे, बट पता होना चाहिए, है ना. So for marriage and divorce, they have Parsi Marriage and Divorce Act 1936. Amendment in 1988. Recent amendment जो हुआ था. For succession, Indian Succession Act only. Guardianship and Wards Act. ठीक है. Succession के लिए Indian Succession Act, IS Act 1925. For guardianship, and Wards Act. क्योंकि गार्डियनशिप एंड वार्ड्स एक्ट सेक्युलर लॉ है एक. ठीक है. Just give me a minute. Okay. So I hope everyone has understood the applicability of these acts.
Excuse me, sir.
Yes, please.
Sir, people have questions in the chat box also. If you could
I
just
will.
follow.
हाँ देखता हूँ, मैं भी देखता हूँ. Sir, I have joined from my desktop. Sir, widow
Sir,
daughter-in-law is
please,
earning. I'll see.
sir, please reopen the page, sir. I need to write down. Please reopen the page.
Yes. Give me 1 minute. Give me 1 minute. I'll reopen. कहीं नहीं जा रहा हूँ, यहीं पर हूँ मैं, आराम से. ठीक है. The Hindu Disposition Property Act 1916. हाँ ठीक है. 1916 है. मैंने क्या लिखा है? कुछ और लिखा है क्या?
So 1956.
हाँ करेक्ट. 1916 है वो. सॉरी, आई एम सो सॉरी. वो जो पहले वाले एक्ट्स थे ना, उनके भाव में बह गया मैं. कहाँ गया? And thank you for pointing out 1916. Correct. Okay. Sir, if widowed daughter-in-law is earning, then also maintenance shall be given. Oh, Shrishti Rungta, don't come to merits now. This is all we are going to learn when we will study the maintenance part. I can answer this right now, but you will be in problem. You will have many other doubts जो simple class के through clarify हो जाएंगे. So maintenance कब मिलेगी? Because maintenance has its own book now. Maintenance तो अपने आप पे commentary है ना. Maintenance के there will be thousands and thousands of question. कि डॉटर इन लॉ अर्न कर रही है, हस्बैंड अर्न कर रहा है, क्या रेलिवेंट होगा, व्हाट विल बी द क्राइटेरिया फॉर दिस, वी विल ऑल लर्न दैट व्हेन वी विल कम फॉर द मेंटेनेंस पार्ट. डू नॉट वरी, आई विल नॉट लीव इवन अ सिंगल थिंग when I will teach you maintenance. Okay, so if widowed daughter-in-law is earning, then also maintenance shall be given. We will deal with it in later stage. I'm not going to answer this right now, क्योंकि अगर आपको स्पून फीडिंग नॉलेज दूंगा, आपको वो क्वेश्चन का आंसर गलत भी लग सकता है एंड देन प्रॉब्लम्स होंगी. तो स्पून फीडिंग नॉलेज नहीं लेंगे, हम आराम से डिटेल में पढ़ेंगे कॉन्सेप्ट को जुरिस्प्रूडेंस समझते हुए. ओके ओके, एक ही तो डाउट है, और कौन सा डाउट है मेरे को नहीं समझ आ रहा कहीं पे.
Sir, there is one more doubt that is Nikita Kumari is asking.
Sir, can any Hindu or Muslim can themselves at their own will subject themselves to Indian Succession Act? Sir, can Hindu or Muslim can themselves at their own will subject themselves in, okay, just a minute. और किसका है? Nikita, again, this doubt will I'll clarify when I'll teach you this succession part. Okay? कोई भी डाउट मेरिट से रिलेटेड अभी हम नहीं वो करेंगे. और किसी का डाउट है अक्षय?
नहीं है सर.
Excuse me, sir.
Yes.
Sir, I have a doubt, but it's not related to the topic which you have stated right now. Can I ask?
Just give me 1 minute. Just give me 1 minute, please.
Sure, sure.
Yes. हाँ, बोलिए क्या डाउट था आपका?
सर, मैं कहीं पढ़ रहा था कि जैसे कि अगर कोई हिंदू में कन्वर्ट करना चाहता है मुस्लिम, तो वो हिंदू में कन्वर्ट कर सकता है. अगर मुस्लिम है, हिंदू है, तो वो मुस्लिम में कन्वर्ट कर सकता है या क्रिश्चियन में कन्वर्ट कर सकता है थ्रू मैरिज या जो भी चीजें हैं. बट पारसीज में आप कन्वर्ट नहीं कर सकते. तो सर
अगेन यू आर आस्किंग अ डाउट फॉर कन्वर्जन. पढ़ेंगे, हम सब कुछ पढ़ेंगे, ठीक है, कि कन्वर्ट किस में कर सकते हैं, किस में नहीं कर सकते हैं. अभी सी हम स्टेप बाय स्टेप चलेंगे. आई टोल्ड यू दैट दिस क्लास इज गोइंग टू एक्सटेंड फॉर 2 to 3 months इजीली. हम जब पढ़ेंगे कन्वर्जन का, कौन क्या है क्या नहीं है, क्या कन्वर्ट हो सकता है, वी विल ऑल स्टडी दैट. ठीक है. हाँ, जैसे अभी जो मोस्ट रेलिवेंट डाउट है वो किसका था? निकिता का. निकिता हैज एक्चुअली आस्क्ड मी द क्वेश्चन फॉर एप्लीकेबिलिटी. Sir, can Hindu or Muslim can subject themselves at their own will? No, Nikita, they cannot subject themselves. Law is well settled. They cannot deviate from the statute. Otherwise, you know what will be the problem, Nikita? Suppose if one Hindu, there is a dispute between two Hindus. One Hindu, if they are not going to get relief under Hindu Succession Act, they will say, I will get relief under Indian Succession Act. So he want himself to be treated under Indian Succession Act. So this is not how it is going to be dealt with. So they have their own personal law. They have their own set of norms which has got the statutory recognition, so they will be dealt under that only. Okay, Nikita? I hope I have made myself clear. I answered you because your doubt was in relation to applicability. For all other people, I will certainly clarify doubt when I'll go to that particular topic. We will go topic wise, and otherwise problems हो जाएगी, आप नहीं समझ पाओगे चीजों को, complication रहेगा. ठीक है, इतना सबको समझ आया? Okay.
Yes, sir.
Let's take one test now. प्रार्थना said yes sir. प्रार्थना, वीडियो तो चालू कर नहीं पाओगे आप, मुझे लगता है. Can you switch on your video?
Sir, am I visible?
You are not. Yes, now you are on. You are visible. Okay, now Prathana, just see in the screen. Do not look at your notebook because I can find out whether you're looking in the notebook or not. And tell me, just wait. Let me have the speaker view.
Sir, your mic is off. Sir.
Yes. Because she's going to speak now. Yes, tell Prathana what others act.
Sir, I did not hear your question because you were muted.
Okay, I'm so sorry. I'm telling you this. Without seeing in the screen, repeat all the acts which I have taught you. All the acts, just only act. It provides what? It's okay.
Sir, for Hindus, it is the first act that is dealing with marriage, divorce, maintenance, separation. It is the Hindu Marriage Act. Followed by it is the Hindu Succession Act. And along with Hindu Succession Act, for succession, we also have Indian Succession Act, which deals with testamentary succession for Hindus, but not intestate succession. And followed by that, we have the Hindu Minority Guardianship Act. After that, we have the Adoption Act. I like to call it HAGA, the Hindu Adoption and I'm not getting the name right, but it is the Adoption Act. Followed by that, it will be the Hindu Disposition of Property Act. For Muslims, we have the Waqf Act for governance. We have the Sikh Section Act I'm forgetting the name, that is for procedural aspect of marriage because the substantive part is dealt with in Quran. And we have the Dissolution of Muslim Marriages Act, which is for divorce of Muslim women and their right to residence. For Christians, we have the Indian Christian Marriage Act, we have Indian Succession Act, we have Guardianship and Wards Act. That is there for Hindus also. I forgot to mention it. And for Parsis also, we have Parsi Marriage Act, and then we have the similar acts that are there.
Okay. Raksha, Prathana has missed something. Any act? Raksha was thinking something else or what? Has she missed anything?
Sir, she was keep speaking, so I am not able to identify which one is missed, but some of them are missed.
Aishwarya has pointed out she missed Guardianship and Wards Act.
Hindu Deposition.
I did mention
okay,
it later.
No problem. So in next class, we are not completing this class now. Okay, there will be class till 6. I'm just telling you in the next class, you need to have this understanding of all the acts. Okay, if I ask you, you need to tell me immediately without seeing like this and this. Okay, without doing this screen or your notebook. Okay, and this is how we are going to study now. सब कुछ हमारी फिंगर टिप्स पे होना चाहिए प्री और मेंस का. प्री में क्या है, आपने एक्ट्स पढ़ लिए. मेंस के लिए क्या है, यू नो द little bit of description of those acts for practical purposes also. Okay, let's go to understand now. This is the last thing we are going to deal with today. We are starting now Hindu law. I wanted to start actually from Muslim law, but क्योंकि हिंदू लॉ से लोग ज्यादातर फैमिलियर रहते हैं, क्लासेस कॉलेज की क्लासेस में भी ज्यादातर पढ़ाया जाता है, सो आई एम स्टार्टिंग विद हिंदू लॉ. क्योंकि कंफ्यूज हो जाओगे थोड़ा सा आप अगर मुस्लिम लॉ डायरेक्टली स्टार्ट किया जाएगा. तो सबसे पहले हम स्टार्ट करेंगे हिंदू लॉ. हिंदू लॉ में फर्स्ट ऑफ ऑल वी आर गोइंग टू डील विद हु इज हिंदू. ओके, सो बिफोर वी डील विद दिस पर्टिकुलर कॉन्सेप्ट, we are going to have one break. Okay, short break for 20 minutes. If you have not eaten your food, have lunch, have tea and coffee, come over with your this sleepiness and attend the class after that. We will have the next class at 4:20 or 4:25. I'm not okay, let's start. Keep making notes if you wish to. Who is Hindu under Hindu law? Okay. So before we start anything, there are few books which you can also go through apart from my teaching. You can refer Mulla, 2 volumes book. If you do not want to refer Mulla, if you think it's quite voluminous, you can go for Paras Diwan, Family Law. You should buy Paras Diwan Family Law. Or you can go for Poonam Pradhan on Family Law, especially Hindu law. For Hindu law I'm talking about, not
Sir,
family law. Yes.
sir, आपकी ऑडियो बहुत कम आ रही है. Can you just check it once?
अभी भी कम आ रही है उत्कर्ष?
सर शायद मेरे सिस्टम, एक बार आप बाकियों से भी पूछ लीजिए कहीं मेरे सिस्टम में कम आ रही हो.
हमेशा मेरी आवाज कम आ रही है, उतनी ही आ रही है?
Sir, your voice is proper.
Proper है उत्कर्ष. I'm so sorry. हो सकता है आपने वॉल्यूम कुछ डाउन करके रखा हो. Try it.
Let me check, sir.
Excuse me, sir.
Yes, just a minute. Yeah.
So what was the third author you were referring to?
Poonam Pradhan.
Okay, sir. Thank you.
सर आप कंटिन्यू करिए, मैं देख लूंगा.
Okay, okay. Just a minute. Okay. Then there is a book, if you want to go for easy books, okay, easy you can go for Agarwal or Kesari. ये कुछ लाइट बुक्स हैं, ठीक है. थोड़ा सा डीप में जाना, सबसे ज्यादा डीप में जाना है तो मुल्ला, हिंदू लॉ, पारस दीवान, पूनम प्रधान, ये सब अच्छी बुक्स हैं. ओके. हम ये बता ही चुके हैं कि कितने टाइप से डिवाइड करना है हमको हिंदू लॉ. फैमिली डायमेंशन है, एंड देन देयर इज द प्रॉपर्टी डायमेंशन, मैरिज, डाइवोर्स, adoption, separation, legitimacy, succession, all that. So now we are going to study who is Hindu. तो हिंदू सेक्शन 2 ऑफ हिंदू मैरिज एक्ट में दिया हुआ है, एंड सेक्शन 2 ऑफ हिंदू सक्सेशन एक्ट में भी दिया हुआ है हु इज हिंदू. दोनों में डेफिनेशन सेम है. Section 2 HMA and Section 2 Hindu Succession Act 1956, दोनों में सेम डेफिनेशन है. ओके, बट हम उसके पहले हम देखेंगे कि बिफोर वी गो टू दिस डेफिनेशन वी नीड टू फाइंड आउट फ्यू थिंग्स. तो जो हिंदू था अर्लियर, बिफोर दीज एक्ट्स कम इनटू एग्जिस्टेंस, फ्रॉम द बिगिनिंग इटसेल्फ, मैं बता रहा हूँ आपको, जब ये सिविलाइजेशन वगैरह थे, इंडियन वाली सिविलाइजेशन, अर्लियर Hindu had only territorial significance. अगर आप बहुत सारे आर्टिकल्स को देखेंगे बड़े बड़े ऑथर्स के, जो पूनम प्रधान या पारस दीवान लिखे हुए हैं, तो अर्लियर दे यूज्ड टू से दैट हिंदूज ओनली हैड द टेरिटोरियल सिग्निफिकेंस. व्हाट इज दिस टेरिटोरियल सिग्निफिकेंस? ग्रीक में एक वर्ड था, दे यूज्ड टू यूज वर्ड इंडोई. इंडोई मींस inhabitant of Hindu Valley means all persons who lived beyond Indian Valley. Okay. So as I told you, Hindus earlier, they were not having any creedal connotation. They were not having any religious connotation. Okay, they had the territorial significance that okay, Hindu is someone who lives here. Okay, who lives beyond Indian Valley civilization or this Indus River or inhabitant of Hindu Valley. They were known as Hindu. But when the when the Mughal Empire came in existence, from that time, the Hindu also got the religious connotation. Okay. So today Hindu has lost territorial significance. So someone is living in America also, he can also be Hindu. Someone is living in Australia, he can also be Hindu. So it is not territorial significance. Okay, there are many ways, I will tell you why. So there were people who were not Hindu. और ऐसे लिखते हैं, just a minute. Before 1955, a person who was a Hindu by religion, it's an important word, Hindu by religion, क्या मतलब होता है? We will see that. What is the meaning of this? We will find out this. A person who was Hindu by religion was certainly a Hindu, but converse was not true. इसका क्या मतलब है? When I say I'm Hindu by religion, और किसी प्रकार के भी हिंदू होते हैं, is there any other kinds of Hindus also? So before 1955, the position was a person who was Hindu by religion was certainly a Hindu. When I say Hindu by religion, means a person who's practicing and professing the Hindu religion, who's following the Dharma Shastra, who's following the Gita, who's following the Smritis, and there are many ways. I'll tell you that in later stage. They were certainly a Hindu. But even if someone was not following these practices, they were also considered as Hindu. Okay. So a person who was Hindu by religion was certainly a Hindu, but converse was not true. So even someone who was not practicing this Hindu religion, they were also Hindu by what? I will tell you that. So there's a Hindu by religion, Hindu by birth, and Hindu by law. हम इन चीजों का मतलब देखेंगे. Hindu by religion, Hindu by birth, and Hindu by law. So Hindu by religion क्या होता है? Hindu by religion is something जो कि हिंदू की जो प्रैक्टिसेस हैं उनको प्रैक्टिस करता है, प्रोफेस करता है. ओके. हिंदू बाय बर्थ क्या है? हिंदू बाय बर्थ है कि अगर if you're one of the parents or both the parents are Hindus, even if you are not following those practices, you are Hindu by birth. So when someone says I'm not Hindu, whether he's saying Hindu, he's not Hindu by religion, or he's saying he's not Hindu by birth, or he's saying he's not Hindu by law. So Hindu by religion is someone who practices and professes the Hindu religion. Hindu by birth does not matter whether he practices or not, but he has taken birth with the parents, whether he's one of the parents or both the parents are Hindu. Or Hindu by law means He is actually not taken birth under Hindu family, or he's not taken birth, he's not practicing a profession Hindu religion. So suppose if I say I don't follow any religion, law says still you are Hindu. If I say I don't know whether I'm Muslim, I don't know whether I'm Jews, or I don't know whether I'm Christian, so law will say you are Hindu by law. Maybe you're not Hindu by religion. So there are three kinds of Hindus: Hindu by religion, Hindu by birth, and Hindu by law. First, we will see Hindu by birth, Hindu by religion. So write down any person who follow Hindu religion in any of its form by practice or professing it is a Hindu. Now you need to ask one question. बहुत सारे लोग हम पढ़ लेते हैं प्रैक्टिस, लेकिन प्रैक्टिस होती क्या है? हाउ विल यू फाइंड आउट द प्रैक्टिस? हाउ टू फॉलो द हिंदू रिलीजन? हाउ टू practice, or what are the evidence that someone is practicing Hindu religion? तो कैसे पता चलोगे how to practice? You will find out that they believe in Hindu god or goddess. One, there are many ways on the basis of which you believe in Hindu god or goddess. There are many margs, there are many path. जैसे एक मार्ग होता है भक्ति मार्ग, ओके, ज्ञान मार्ग, कर्म मार्ग. Suppose if he is saying that he does not follow, someone has come जिसके ऊपर हिंदू लॉ एप्लीकेबल होने का क्वेश्चन है, he is saying I am not Hindu by religion. Now the inhabitants, the residents, the neighbors of that particular person will come and be witness in the court and will say that okay, ये कर्म मार्ग पे भरोसा रखता है. कर्म मार्ग मतलब a person who only believes in karma. So anyone who practices Hindu religion, whether he is Jain, whether he is Sikh, whether he is Jain, Sikh or Buddha, ultimate aim is to the realization of self. What is that ultimate aim? Object is realization of self. अब रियलाइजेशन ऑफ सेल्फ कैसे करते हो आप? रियलाइजेशन ऑफ सेल्फ करते हो जैसे हिंदू में आपने सुना होगा मीराबाई थी ना, आप लोगों ने सुना होगा मीराबाई के बारे में. मीराबाई कैसे जा रही थी? मीराबाई केवल कृष्ण को मानती थी कि कृष्ण मेरे हस्बैंड है. व्हाट वाज दैट? दैट वाज अ भक्ति मार्ग, कि मतलब आई डोंट केयर अबाउट एनीथिंग, आई जस्ट फॉलो कृष्णा. सो फॉलोइंग कृष्णा शी रियलाइज्ड द सेल्फ, दैट इज कॉल्ड भक्ति मार्ग. तो मीराबाई के आस पड़ोस वाले आएंगे कोर्ट में और बोलेंगे हाँ हाँ ये तो एकदम कृष्ण भगवान की एकदम ऐसी भयंकर पूजा करती हैं, दैट्स कॉल्ड भक्ति मार्ग. तो कोर्ट ये कंक्लूजन पे आएगा क्योंकि ये इतनी पूजा करती थी, इट मींस शी वाज प्रैक्टिसिंग हिंदू रिलीजन, दैट इज कॉल्ड प्रैक्टिस. तो ऐसा नहीं कि आरती लेके आपको एकदम झूमते रहना है 24 घंटे तभी लोग बोलेंगे, ठीक है? तो प्रैक्टिसिंग मतलब एकदम कंप्लीट डिवोशन, भक्ति से जाना. जरूरी नहीं कि आप दीपक जला रहे हो, दैट इज ऑल्सो वन ऑफ द इंडिकेटिंग फैक्टर. अगरबत्तियां लगा रहे हो, दीपक लगा रहे हो, दैट इज ऑल्सो वन ऑफ द इंडिकेटिंग फैक्टर, बट दैट इज नॉट द कंक्लूसिव प्रूफ ऑफ इट. तो भक्ति मार्ग. अब कई लोग होते हैं जो कर्म मार्ग पे भरोसा रखते हैं. व्हाट इज दैट कर्म मार्ग? कर्म मार्ग इज मतलब आई डोंट बिलीव दैट कि मतलब भगवान की पूजा करनी चाहिए, दैट आई नीड टू वर्शिप द गॉड, बट आई बिलीव इन कर्मा, कि कर्म करो और फल के हक की अधिकार जो है, फल की इच्छा मत करो, कि आपने कर्म करते जाओ. जैसे मैं आपको पढ़ा रहा हूं, जैसे आप अभी पढ़ रहे हैं, आई एम टीचिंग यू, यू आर लर्निंग दैट वी आर ऑल डूइंग कर्मा, इट मींस वी आर वर्शिपिंग गॉड. सो जो कर्म योगी होते हैं, द पीपल हु फॉलोज द कर्म थिंग, तो कोर्ट में विटनेस बनेगा और लोग बोलेंगे ओके मिस्टर आदित्य दुबे थे, आकांक्षा बिश्नोई थी, है ना. सपोज इनका क्वेश्चन है वेदर दे आर हिंदू बाय रिलीजन, द क्वेश्चन इज वेदर दे वर प्रैक्टिसिंग हिंदू रिलीजन. Someone will come and say, okay, when Pawan sir used to give lecture for karma, yoga or something, they used to attend class and they used to appreciate it. It means you are following it. That's called practicing it. Okay. So this is also one of the definition that Hindu, how you are practicing. तो books में आपको मिलेगा कि practice करना is an evidence that you are practicing Hindu by religion, means you are going to practice or profess Hindu religion. But how you are practicing? What are the evidences for this? Similar way for Muslims also. Whether I'm going to mosque, it's an evidence that I follow Muslim religion. It means I practice Muslim religion. But उनके criteria जैसे हैं, Muslims के अलग हैं, Hindus के criteria अलग हैं, Christians के criteria अलग हैं, different policies हैं, different laws हैं, different factors हैं. But we are in the Hindu part now. So Hindu by religion मतलब practicing and professing. कैसे practice कर रहे हैं? I have given you. These are the mode: believe in God, bhakti marg, janam marg, karma marg. ठीक है, janam marg and so on. Just a minute. Okay. Another is follow the path of Vedas. कई लोग मिले होंगे आपको जो बोलते हैं नहीं मैं भगवान में बिलीव नहीं रखता, जो मैं तो वेदों में बिलीव रखता हूँ. They are also following Hindu religion. Following in the sense they are practicing Hindu religion. Upanishad, Gita, Smriti, Shrutis. Then there is another way called Tapasya or Akhand Brahmacharya. Akhand Brahmacharya is also a part of Hindu practice. So this is how Hindu religion is practiced. These are few ways. There are many ways apart from this. Okay. Now, when you read section 2(1) of Hindu Marriage Act, everyone kindly open your Bear Act. Kindly open Hindu Marriage Act, Bear Act, section 2. Everyone has opened this Bear Act, section 2(1). Now you will find out application of the act. This act applies. So you need to remember one thing, Hindu की definition क्या है? The definition of Hindu is not provided under any act. There are no judgments which actually provide the definition of, the clear definition of Hindu. So what the law says now, this act says, section 2 when you read, this act applies. तो ये एक्ट जिन जिन लोगों पे अप्लाई होगा वो हिंदू है. सिंपल. ओके. सो नाउ वी आर गोइंग टू सी कि एक्ट किन पिन पे अप्लाई होता है. सो दिस इज ट्राइंग टू से, नाउ दिस डेफिनेशन इज covering Hindu by religion, Hindu by birth, and Hindu by law. So if now when you see this act applies A to any person who is a Hindu by religion in any of its forms, development, including a Virashava or Lingayat or the follower of the Brahmo, Prarthana or Arya Samaj. So this definition A, I'm on the point of A only. This is talking about Hindu by religion. बेरेक्ट में ए के सामने मार्क कर लो, हिंदू बाय रिलीजन. दिस डेफिनेशन सेक्शन 2(1)(a) is inclusive in nature. Inclusive means जो भी चीजें, जो भी सेक्ट, जो whatever the things will come, it will include this. This is not an exhaustive definition. Okay, inclusive definition है ये. So it includes Virashiva, Lingayat or the follower of the Brahmo, Prarthana और आर्य समाज. Okay. अब इसमें दो वर्ड यूज किए गए हैं, वीराशिवा और लिंगायत. वीराशिवा और लिंगायत कौन होते हैं? वीराशिवा और लिंगायत, there are two words used.
The followers of Shiva and Vishnu.
Correct, correct. No, Lingayat also does not follow Vishnu. They also follow Shiva. But what is the difference? Both of them follow Shiva. They both follow शिवा. बट दोनों में डिफरेंस ये होता है, जो लिंगायत होते हैं ये बहुत ज्यादा एवर्स होते हैं विष्णु के, वेरी मच अपोजिट. दे डू नॉट वांट, दे कैन नॉट सी एनीवन वर्शिपिंग विष्णु. विराशवा थोड़े से लाइट होते हैं, दे आर नॉट मच एवर्स टू विष्णु. ओके, तो विराशवा, लिंगायत, ब्राह्मो जो ब्रह्म की पूजा करते हैं, प्रार्थना और आर्य समाज जो आर्य समाज का अलग से चल रहा है, ये सारे कुछ सेक्ट हैं जो हिंदू बाई रिलीजन में आते हैं. दे आर द पार्ट ऑफ हिंदू बाई रिलीजन. ओके, अपार्ट फ्रॉम दिस इफ यू वांट टू हैव देन तांत्रिक. अगर कोई तांत्रिक है, ही कैन नॉट से ही इज नॉट अ हिंदू बिकॉज ही इज ऑल्सो प्रैक्टिसिंग दैट. ठीक है, तांत्रिक हो गए. उसके बाद में वर्शिपर ऑफ कृष्णा, विष्णु, शक्ति, ये सब हिंदू बाय रिलीजन. मैं ये नहीं बोल रहा हूं कि हिंदू हैं, सम मुस्लिम, सम क्रिश्चियन कैन ऑल्सो प्रैक्टिस दैट, बट हिंदू बाय रिलीजन मतलब वो प्रैक्टिस कर रहे हैं हिंदुइज्म की. बाकी बहुत सारे और भी फैक्टर्स होते हैं कि वो हिंदू है कि मुस्लिम है कि क्रिश्चियन है. वी विल फाइंड आउट दैट इन लेटर स्टेज. सो फर्स्ट थिंग वी नीड टू अंडरस्टैंड हिंदू बाय रिलीजन मतलब एनीवन हु फॉलोज हिंदू रिलीजन, हु प्रैक्टिस एंड प्रोफेस हिंदू रिलीजन. इतना सबको समझ आया कैसे प्रैक्टिस एंड प्रोफेस होता है? फर्स्ट पार्ट डन. ओके, नाउ जस्ट अ मिनट. So write down, there are two types, write down, two types of person fall under this category. There are two types of person fall under this category. One, those who are originally Hindu, those who are originally Hindus, comma, Jains, Sikh or Buddhist by religion. Hindus by religion. By religion, I have told you what is the meaning of by religion. Who follow and practice these marks, Upanishad, Gita, and so on. Okay. And second, B, those who are converts, those who are converts or reconverts to Hindu. Who are converts or reconverts to Hindu, Jain, Sikh or Buddhist. हिंदू बाय रिलीजन में देयर आर टू कैटेगरीज. ठीक है, कैसे प्रैक्टिस होता है वो आई हैव ऑलरेडी टोल्ड यू. नाउ हेडिंग डालो फॉलोअर्स ऑफ, उसी हिंदू बाय रिलीजन में आएगा, फॉलोअर्स ऑफ जैनिज्म, सिखिज्म एंड बुद्धिज्म. क्या डिफरेंस है जैन में, बुद्धिस्ट में और सिख में? क्या डिफरेंस है? हाउ विल यू फाइंड दिस आउट? one liner, just have one liner. Jainism rejects the authority of Vedas. Jainism, they rejects the authority of Vedas and discard all ceremonies and rituals. does not believe in existence of God. Believe in tapasya. Tapasya means by discarding worldly life and worldly manifestation. कि दुनिया में जो चल रहा है सब मोह माया है,
Excuse me, sir.
तपस्या ही सब कुछ है. हाँ, yes.
Sir, in Jains they have Tirthankars.
Yes.
So they basically admire their Tirthankars as God only.
Yes. But they do not believe in Shiva, Vishnu. They do not believe in these gods.
Okay.
Brahma.
Okay. Thank you.
Basically, those Tirthankars also, they say, they preach about tapasya. They do not say that you worship them. वो बोलते हैं कि आप तपस्या कीजिए, तपस्या से आप जो वर्ल्डली मैनिफेस्टेशन से आप इनसे ओवरकम हो जाएंगे. मुझे जैसे आप when you go for specific Hindu religion, you will say that अगर आप शिवा की पूजा कर रहे हैं या विष्णु की पूजा कर रहे हैं, if you are worshipping Vishnu or Brahma, you can get heaven. But in Jainism, it's not like that. They will not say that if you worship me, the Tirthankars or Vishnu or Shiva, you will go to heaven. They say you can get everything only by tapasya. Okay. So ultimate is that they follow tapasya principles. Now Sikh.
Sir,
They believe
tapasya what? Sir, they do tapasya what? Sir, they do tapasya what? Like we do tapasya.
They do tapasya. Tapasya मतलब आप क्या? I didn't get you. What you asking?
So like in Hindus, they do worshipping of God, and this is called their tapasya. And
No. Tapasya is something different. Tapasya is when you are tapasya is different. Puja is different. मैं रात में अगर ओम जय जगदीश हरे की आरती गा रहा हूँ, that is not tapasya. There's just a rituals I'm following. मैं बोल रहा हूँ इसको टीका लगा देना, इसको चंदन लगा देना. That's different. Tapasya is, अब there are various kinds of tapasya also. Tapasya is when I'm suppose मैं कहीं बैठा हुआ हूँ और केवल शांति के साथ में ऐसा मैं बैठा हुआ हूँ. Tapasya is when I'm renunciating something. मैं अपने कपड़े मैंने छोड़ दिए, मैंने खाना पीना छोड़ दिया. That is all the part of tapasya. तो मैं ये नहीं बोल रहा हूँ कि
like
हिंदू में तपस्या नहीं
meditation.
है. See,
In
there is
tapasya, people renounce worldly pleasures, I should say.
correct. Suppose अगर मैंने ये आज घोषणा कर दी कि मैं टीवी आज से नहीं देखूंगा, that is also a part of तपस्या. मैंने ये बोल दिया कि मैं आज के बाद सुबह लहसुन प्याज and chicken I will not eat, that is also a tapasya. You are renouncing something, not you are renouncing the pleasures of the world. ठीक है ना? मैंने बोला मैं फ्रिज का ठंडा पानी नहीं पीऊंगा, that is also a tapasya. Anything which you are renouncing from which you get the pleasure. Suppose if a person जिसको ऑलरेडी फ्रिज का पानी पसंद नहीं है, वो बोल रहा है मैंने फ्रिज का पानी छोड़ दिया, दैट इज नॉट तपस्या फॉर हिम. तपस्या इज समथिंग व्हेन यू लव समथिंग एंड यू आर अनाउंसिंग दैट. सो इट इज बिलीव्ड दैट एवरीवन लव्स दिस वर्ल्डली प्लेजर एंड दे आर अनाउंसिंग दैट. सबको अपने कपड़े पसंद है, लेकिन जब आप कपड़े पहनना जैसे छोड़ देते हैं जैनिज्म में, है ना, तो वो तपस्या मानी जाती है उनकी. और उसी के थ्रू मतलब दे डोंट केयर अबाउट एनीथिंग इफ समथिंग इज टेकन अवे फ्रॉम देम. दैट इज कॉल्ड तपस्या. तपस्या वो हमने जो ओम नमः शिवाय सीरियल्स देखे, ओम ब्रह्मदेव नमः, वो तपस्या है because they are also renouncing something, but there are various kinds of tapasyas. Okay.
Okay.
Now
Sir.
now write down on Sikh. Sikh believe that God is one. They also discard all forms of Hindu worship and class distinction. केवल गुरु को मानते हैं वो ना. Come to Buddhism. Write down Buddhism. Buddhists believe that human life is one of suffering. Human life is one of suffering, comma, and that meditation, comma, spiritual and physical labor, comma, good behavior, spiritual and physical labor, and good behavior are the ways to achieve enlightenment or nirvana.
Sir, can you repeat once?
Buddhists believe that human life is one of the suffering. मतलब वो they think कि जो human life होती है हमेशा सफर ही करती रहती है वो. अभी मतलब 10th में है तो 10th के एग्जाम दे रहे हो, फिर 12th आ गया, फिर है ना, फिर अब लॉ कर रहे हो तो क्लास में बैठना पड़ रहा है 4 दिन. मतलब ह्यूमन लाइफ कंप्लीटली सफरिंग है. आप इन सब मोह माया से कभी एडवोकेट बन गए, फिर आपको हाई कोर्ट का जज बनना है, फिर सुप्रीम कोर्ट का जज बनना है, फिर व्हेन यू हैव बिकम चीफ जस्टिस ऑफ इंडिया, आफ्टर दैट अगेन यू हैव कम बैक टू द सिचुएशन ऑफ सफरिंग. नो वन इज आस्किंग यू नाउ. सो ऑल दैट दे बिलीव दैट एंटायर ह्यूमन लाइफ इज all about suffering. Entire life you suffer from all these moh maya, lalach, aspirations. So they believe that you leave all that, and from meditation, spiritual and physical labor, and good behavior are the ways to enlightenment. Self satisfaction. You must have the self satisfaction in life. Okay. So as I told you, Hindu by religion में दो लोग आते हैं. One is those who are originally Hindu, Jain, Sikh, Buddhist by religion. By religion we have now come to know what is the meaning of by religion. Hindu by religion, Jain by religion, Buddhist by religion, who practice and who profess Hindu, Buddha, Sikh, and so on. Second point I made you right, who converts and reconverts to Hinduism. Okay, right in this. Converts or reconverts to Hinduism. They are also Hindus. So हिंदू की डेफिनेशन बहुत ही इंक्लूसिव है. मतलब जो कुछ नहीं है वो हिंदू है. ठीक है ना? सिंपल. If people are not following any law, if they are not from any religion, they are Hindu as per the law. They may not be Hindu by religion, but they are Hindu by law. Okay. So converts and reconverts to Hinduism. Now write down. And you need to remember one thing, that Hindus में धर्म शास्त्र जो हिंदू के हैं, they do not prescribe any ceremony for conversion to Hinduism. There are no ceremonies, explicit ceremonies कि आपने ये ceremony कर लिया, जैसे क्रिश्चियंस में होता है कि आपने ये ceremony कर लिया तो आप क्या बन जाएंगे, क्रिश्चियन बन जाएंगे या मुस्लिम बन जाएंगे या पारसी बन जाएंगे. हिंदूज में ऐसी कोई ceremony नहीं है. There are few ways which you are reading on the basis of which you become Hindu. So according to Dharma Shastra, there is no ceremony for conversion to Hinduism except आर्य समाजिस्ट. आर्य समाजिस्ट भी हिंदू हैं. ठीक है. आर्य समाजिस्ट prescribe the procedure for becoming Hindu, the ceremony for becoming Hindu, and it is called शुद्धि. क्या बोलते हैं उसको? शुद्धि. SUDHI. But a person who undergoes that ceremony, they are known as Arya Samajist Hindu, not normal Hindu. Arya Samajist Hindu. Now write down a question. इस टाइप के मेंस में क्वेश्चंस आते हैं. The question is whether a person may also become a Hindu, if after expressing an intention, comma, expressly or impliedly, comma, he lives as a Hindu and the community or caste into the fold of which he is ushered, USHED, S-H-E-R-D, ushered in, comma, accepts him as a member of that community or caste, question mark. Whether this person can also be considered as Hindu? Suppose if he is from some other religion. Suppose he was a Muslim, or suppose he was a Christian. But वो एक छोटे से गांव में सपोज रह रहा था बहुत दिनों से, और वो देवी माँ की पूजा कर रहा है, वर्शिप फॉलो कर रहा है, और वो अपने आप को बता रहा है कि मैं तो इन भगवान को मानता हूं. And that community has also accepted him. Okay, fine, no problem. Whether that person can also be considered as Hindu, this is the question for your mains exam in judiciary. What is your answer? Write down the answer. Answer is the Supreme Court in Perumal. I'm writing the case name. Landmark judgment. This is the landmark judgment, Perumal versus Ponu Swami, 1971 Supreme Court, 2352. Court held that yes, he can be considered as Hindu, but one has to look to the intention. One has to look to the intention and conduct of the convert, the person who has converted, comma, and if the consensus of the community into which he was initiated is sufficiently indicative of his conversion.
Sir, can you please go a little slow?
Yes, I will go a little slow, don't worry. Step by step आपको भी writing की speed बढ़ानी है, ठीक है ना? I'm just telling you this, in judiciary classes they don't dictate, they just speak. You have to make the notes. But I'm dictating, it's okay, because many of you are on first year, second year, and third year. So you have to increase your speed, okay? Now in such a case, one has to look to the intention and conduct of the convert, comma. यहां तक लिख लिया था आपने? And if the consensus of the community into which he was initiated is sufficiently indicative of his conversion, comma, then the lack of some formalities cannot negate what is an accomplished fact. Full stop. In such a case, no formal ceremony of purification or expiation, expiation, expiation is necessary to effectuate conversion. Write down the second judgment. When a person next judgment is, मतलब not for this question answer is over. Write down the next, उसी में ही next point लिखो. Further, when a person declares that he is a follower of Hindu faith, and if such a declaration is bona fide, it's called bona fide. Follower a Hindu faith, and if such a declaration is bona fide, not made with any ulterior motive or intention. I'm repeating again. Further, when a person declares that he is a follower of Hindu faith, and if such a declaration is bona fide and not made with any ulterior motive or intention, he becomes a Hindu by conversion. Suppose if someone is Christian, but he declares that I'm a Hindu, bona fidely, in a bona fide way, it will be considered that he is a Hindu. Case का नाम लिखो. Judgment name is Mohan Das versus Devasam Board, DEWASON, Devasam Board. 1975 केरला हाई कोर्ट का डिसीजन था ये, KLT 55, 1975 KLT 55.
So sorry, can you repeat the citation, please?
Yes. 1975 KLT, Kerala Law Times, page number 55. Kerala High Court. Okay. So it's an important judgment. तो इस केस के फैक्ट्स क्या रहते हैं? जो द केस व्हिच आई हैव टोल्ड यू, मोहनदास वर्सेस देवासम बोर्ड, देवासन DEWASWAN, Devaswan DEWASWAN, Devaswan board. So in this case, one Jesudas, JESUDAS, who was a Catholic Christian, और बहुत एक फेमस सिंगर रहता है वो, who used to play devotional music of in a Hindu temple. A Catholic Christian, he used to play a devotional music, ठीक है, in a Hindu temple, or he used to worship like a Hindu in a Hindu temple. And he has also filed a declaration, or declaration, don't write, just if you just want to write the major facts, that a Catholic Christian who used to go and play music in Hindu temple, and he also used to worship Hindu temple, he declared in Hindu temple, and the declaration was like this: I declare that I am a follower of Hindu faith. He declared that, and everyone believed that it was made in good faith, and from that the judgment came, this Mohandas versus Devasam board. Court held that Jesudas was a Hindu and could not be prevented from entering the temple, क्योंकि जब वो उसको म्यूजिक जब प्ले करना था उस टेम्पल पे, तो लोग उसको मना करते हैं that you are not Hindu and you will not be allowed in that particular temple. So the question before he filed a petition, and the question before the court was that whether that Jesudas, who was Catholic Christian, whether he was a Hindu or not, because he has made this declaration. So court held that yes, he is a Hindu by religion and his entry should be allowed inside the temple. Understood? Everyone? Okay.
Yes, sir.
Okay. So a non-Hindu will become Hindu by conversion. Hindu by religion तो हमको पता चला, Hindu by religion में दो हमने चीजें पढ़ी थी, who practice and who convert. Who convert और reconvert में हमें तीन चीजें याद रखनी है. First, if anyone is undergoing a ceremony, formal ceremony of conversion or reconversion prescribed by law, then obviously he is a Hindu by conversion. Second, if he expresses a bona fide declaration that he is a Hindu, then he also becomes the part of Hindu. And if bona fides, अगर वो अपना practice कर रहा है, and if community has accepted him, then also he becomes Hindu by conversion. There are three ways how a person or non-Hindu can become Hindu by conversion. बहुत कोई हार्ड एंड फास्ट मेथड्स नहीं है, इंक्लूसिव रिलीजन है, ठीक है ना. Now, next heading है Hindu by birth. Write down this, Hindu by birth. Hindu by birth first है Hindu by birth का मतलब होता है when both the parents are Hindus. Very simple, right? That any children born out of Hindu parents are Hindus. It is, so he does not have to, even if he is not practicing or professing, then also he is Hindu. Remember, this is very important here. When I say when both the parents are Hindu, even if he is not doing anything, he will be considered as Hindu. Very important line. Okay. Second is when one parent is Hindu. Now for this, there are few conditions which you need to write. When one of the parent is Hindu, या तो माँ हिंदू है, ये मदर हिंदू है, या तो फादर हिंदू है, तो बच्चा क्या होगा? ठीक है, सपोज एक मुस्लिम और हिंदू की अगर शादी होती है और बेबी होता है, चाइल्ड होता है, उसका कौन सा रिलीजन होगा? सो इट डिपेंड्स कि वो कौन से रिलीजन को फॉलो कर रहा है, कौन से रिलीजन को प्रैक्टिस एंड प्रोफेस कर रहा है. राइट डाउन दिस. अगर Right on. A person will be Hindu if the following conditions are satisfied when one parent is Hindu. One, at the time of his birth, one of the parent was Hindu. One of the parent was Hindu. Plus, second condition is also required, that he is brought up as a member of the tribe, community, group, or family to which Hindu parent belonged at the time of the birth of the child. तो जब वो बच्चा हुआ था, when the child was taken birth, उसको कैसे, किस फैमिली में रखा गया है, किस ट्राइब में रखा गया है, किस कम्युनिटी में रखा गया है. अगर पता चला कि हिंदू ट्राइब में रखा गया है, हिंदू कम्युनिटी में रखा गया है, सिख है, क्रिश्चियन है, सिख है, बुद्ध है ना, या कोई भी कम्युनिटी है, कोई भी सेक्ट है, लिंगायत है, एनीथिंग, it will be considered that he's a Hindu. But this second condition is very important, and it does not apply when both the parents are Hindu. It applies when one parent is from some other religion and one parent is Hindu. Okay. Just a minute. इसमें लिखो, one more thing you need to write in this. It is to be noted that the child's religion, it is not necessary that It is not necessary that child had the religion the same of his father at the time of his birth. Full stop. If the mother of the child at the time of the child's birth was Hindu and the child was brought up as a Hindu, फिर से बोल रहा हूं मैं, if the mother of a child at the time of the child birth was a Hindu and the child was brought up as a Hindu, comma, the child would be Hindu. पहले क्या होता था? Earlier what used to happen that if it was all confined to the father problem. If the father was not a Hindu, the child would not have been considered as a Hindu. Now, even if the mother belonged to that particular community when the child was taken birth, one of the parents, then also the person will be considered as Hindu. The child will be considered as Hindu. कहाँ दिया हुआ है? Kindly see section 2. Explanation B. सबसे नीचे. So when you read explanation, you read the following persons are Hindu, Buddhist, Jain or Sikh by religion, as the case may be. Any child, legitimate or illegitimate, both of whose parents are Hindu, Buddhist, Jain, Sikh by religion. We have read that. We know this, right? Second, any child, legitimate or illegitimate. Remember this, okay? Read it very carefully. One of whose parents is a Hindu. One of whose parents means either mother or father, not necessarily father. One of whose parents is a Hindu, Buddha, Jain or Sikh by religion, and who is brought up as a member of the tribe, community, group or family to which such parent belong or belonged. It means even if the mother was a Hindu when the child was taken birth, now she is not a Hindu, does not matter. Because the word used is belonged. See, belongs or belonged. So this can also be mains question sometime. कि suppose एक वाइफ एक सपोज एक वुमेन है, एक मैन है, शादी होती है दोनों की, ओके दोनों अलग अलग रिलीजन में शादी होती है, मदर एंड फादर दोनों अलग अलग रिलीजन के हैं. मदर सपोज हिंदू है, जब बच्चा हुआ था तो मदर हिंदू थी, शी वॉज ए हिंदू when the child took birth, but after some time she got converted. The question is, when the child was taken birth, she was Hindu. Child belong to what religion? Depends first कि वो कौन सी फैमिली में रह रहे हैं. अगर वो वैसे हिंदू फैमिली में सेक्ट में पल बढ़ रहा है, रह रहा है, in that situation he will be Hindu because the word used is belonged. Present situation की वो बात नहीं करता है provision that both of them or one of them today when the question arises before the court has to be Hindu. No. Even the time when the child took birth, if one of the parent was a Hindu, belonged to Hindu, any community, sect, then also he's a Hindu by religion. Understood? Because the word relevance of the word belonged is there. So today's situation you don't have to see. Even if that time he belonged to the particular he or she belonged to that particular religion, that also fine. ठीक है? Suppose मैं एक एग्जांपल देता हूं आपको. एक आप बोलोगे सर ऐसा कहां पर होगा? I'll tell you now. Suppose एक मदर एंड फादर हैं, फादर मुस्लिम है, माँ हिंदू है, ठीक है? बेबी हुआ, बेबी के बाद उन्होंने अपनी जो बच्चा है वो दे दिया अपना नानी नानी के पास में, ग्रैंड मदर एंड ग्रैंडफादर. वो बच्चे को हिंदू की तरह से उसका पालन पोषण कर रहे हैं, लुकिंग आफ्टर द चाइल्ड लाइक ए हिंदू. माँ ने आफ्टर दैट शी हैज आल्सो कन्वर्टेड इनटू मुस्लिम. नाउ द क्वेश्चन अराइजेस whether the child is a Hindu or Muslim. Answer me.
Child is
He is Hindu.
Hindu.
He's a Hindu. Why? Because the relevant time is when the child took birth. In that time, one of the parent was Hindu. Okay? And now the child was brought up into the family of Hindu. So that way he's a Hindu. He or she is Hindu. Understood, everyone?
Yes, sir.
Yes, sir.
So this is the relevance of the word belonged, belongs or belonged in both way. Write down one case, Menka Gandhi versus Indira Gandhi. Menka Gandhi versus Indira Gandhi. 1984 Delhi High Court. AIR 1984. Citation if you want to write. AIR 1984. Delhi High Court DEL 428. In this case, Sanjay Gandhi's father was a Parsi. In this case, Sanjay Gandhi's father was a Parsi. And a mother, Indira Gandhi, was a Hindu. And a mother, Indira Gandhi, was a Hindu. Full stop. Held that Sanjay Gandhi was a Hindu because one of his parents, namely the mother, was a Hindu. And the held that Sanjay Gandhi was a Hindu because one of his parents, namely the mother, was a Hindu, and she had openly brought up Sanjay as a Hindu. Now I'm asking you one question. Write down. You need to answer this. Again for mains. Is it necessary? Write down. Is it necessary that the child, question is it necessary that the child should be brought up as a member of tribe, community, caste, group, or family to which the Hindu belonged at the time? फिर से बोल देता हूं. Is it necessary that the child should be brought up as a member of a tribe, community, caste, group, or family to which the Hindu belonged at the time of the birth of the child? Question mark. To birth of the child. Birth of the child. Wait. When one parent is Hindu, when one of his parents is Hindu or was Hindu, does not matter. When one of his parents is / was Hindu, to come under the ambit of double inverted comma में लिखिएगा Hindu by birth. To come under the ambit of Hindu by birth. आप एक बार फिर से क्वेश्चन पढ़िए, हो सकता है समझ में नहीं आएगा. Raise your hand. I will tell you what is my question with illustration. But before that, you again read section 2, explanation B. Then you will understand what I'm trying to ask you. The following persons are Hindu, Buddhist, Jain, or Sikh by religion, as the case may be. Any child, legitimate or illegitimate, one of whose parent is a Hindu, Buddhist, Jain, or Sikh by religion, and who is brought up as a member of the tribe, community, group, or family to which such parent belongs or belonged. So my question to you is, in simple word, suppose mother was following Hindu religion, worshipping of Shiva and Vishnu and Brahma. Okay, रोज ओम जय जगदीश हरे होता था घर पे. Father was a Muslim, 5 times namazi. बच्चे का जन्म होता है, a child is taken birth. Later stage, mother is converted, also in Muslim. जो बेबी है वो अपने नाना नानी के यहाँ पलता है. He was brought up in the family of this maternal grandparents जो हिंदू थे, ठीक है. बट जो मैटरनल ग्रैंड पेरेंट्स थे, सपोज वो सिख में कन्वर्ट हो जाते हैं. अब वो जो उसका जो परवरिश हो रही है, जो उसका ब्रॉट अप हो रहा है, जो लुकिंग आफ्टर उसका हो रहा है, इट इज एज पर द सिख रिलीजन, नॉट एज पर द हिंदू रिलीजन, जहां पर वो जिस हिंदू कम्युनिटी जहां से वो पैदा हुआ था. बट अब वो एज पर द सिख रिलीजन में हो रहा है उसका ब्रॉट अप. क्वेश्चन इज, वो बच्चा हिंदू माना जाएगा या नहीं माना जाएगा, एंड वेदर इट इज फुलफिलिंग द कंडीशन ऑफ एक्सप्लेनेशन सेक्शन 2 एक्सप्लेनेशन बी. Why I'm asking you this, आपको बड़ा सिंपल सा लग रहा होगा, but why I'm asking you this is because clause B बोलता है one of whose parents is Hindu, Buddha, Jain, Sikh by religion, who is brought up as a member of the tribe, community, group or family to which such parent belongs. जो मैंने आपको एग्जाम्पल दिया है उसमें जो बेबी हुआ है, जो चाइल्ड हुआ है, he is not bringing up as a Hindu जो उसकी माँ थी, जैसे वो पैदा हुआ था, but he is being of that community, but he is being brought up as a Sikh. Now the question is whether is he Hindu or Muslim, or what religion he will have. किसको किसको क्वेश्चन समझ में नहीं आया है? आंसर करो यार, बहुत सारे लोग हैं यहाँ पे. आंसर इट. सी आई टेल यू. यस यस प्लीज स्पीक.
Yes, so I think as per my understanding, he will not be considered as a Hindu because as per the explanation B, the word and has been used, which means that there's not either of like both the conditions should be fulfilled. And here he has been raised as a Sikh. I mean, one of the condition of him being brought up as a Hindu is not fulfilled. That's why he won't be considered as Hindu.
Okay, you understood the question, right? Correct. So according to her, yes, tell me.
But the Sikhs also be in the category of Hindu?
What are you saying? Please repeat.
Sikhs also be in Hindu.
Correct. But the question here is, you are right, absolutely right, no problem. But the question is, when you read explanation B, it says, it is not talking about religion there. It is talking about who is brought up as a member of the tribe. Which tribe? The tribe where one of the parents belonged. He or she should be brought up same like that tribe. Suppose, according to this explanation, जो literal interpretation जो है, the child if took birth as a Jain, he should be brought up as a Jain, then only it will fall under explanation. If child took birth as a Buddha, he should be brought up as a Buddha. Then only this explanation B will apply. If he has taken birth as a Hindu, pure Hindu, suppose Brahman, he should be brought up as a Brahman, not as a Sikh, not as a Jain. This is what this section is saying. See, read it. Who is brought up as a member of the tribe, community, group, or family to which such parent belongs or belonged. To such parent belonged. To the tribe, community. Now what do you say?
Sir,
Amisha, are you there?
can I point out one thing, sir? I mean, though I understand the question and I truly agree that he won't be considered as a Hindu because of the reason that his mother was a Hindu and his grandparents subsequently became Sikhs. But sir,
So
it
you
says,
need to, okay, hold on. So, okay, you keep on speaking. I'll answer you that after.
and
Yeah.
who is brought up as a member of the tribe, community, group, or family. So he is being brought up as a member of the same family as the family in which the mother belonged. So it could be considered, if you're an opposing counsel, that since it's the same family and the family continues to be a Hindu because they are Sikhs, so they can, the child can pass off as a Hindu by birth.
Okay,
By birth.
Yeah, hold on here. Just, you made a very right point. Now read. Family to which such parent belongs or belonged. Family to which such parent belongs or belonged. It has taken the different shape. Earlier they were same family. Now she
Sir,
has, yes, tell me.
sir, here his parents does not belong to Sikh community. So
They have, that's what I'm asking. That's what I'm telling you. Now the parents of that mother has converted into Sikh through ceremonies. They now worship Guru Gobind Singh. They go to Gurudwaras and all. They have said that they are not following Hindu religion then. They have left that particular community, let me say that. So the answer to this question is, many of you have answered correctly. See, these words, member of the tribe, community, group, or family, when you read this definition, I told you this definition of Hindu is inclusive in nature. You cannot have the literal interpretation of this. So when you read that the Hindu entire definition is inclusive in nature. So these four terms, tribe, community, group, or family, just a moment back, a person has correctly pointed out. These are the terms of ejusdem generis. Ejusdem generis means of the same kind. तो इसका मतलब ये होता है कि either the person belongs to this community and he joins that community जहां पर वो brought up हो रहा है. Suppose जैन था और वो बुद्धिस्ट जैसा अगर brought up हो रहा है, does not matter, still that will be Hindu. So कई बार ऐसे ट्रिकी क्वेश्चन जब आप थोड़ा डिटेल में पढ़ते हैं, ट्रिकी क्वेश्चंस पूछे जाते हैं, तो जिनको लॉ बिल्कुल नहीं पता होता है, दे मेक इट करेक्ट while writing the answer, क्योंकि नहीं पता था उनको. So they say they are Hindu only. How does the community matter? But जिसने explanation B पढ़ा होगा डिटेल में, वो कंफ्यूज हो जाएगा. Okay, but you need to go a bit deeper. Deeper is tribe, community, group, or family. The words which have been used here, they are the terminology, they are the expressions of ejusdem generis, means of the same kind. So even if he belongs to this particular community, but he is brought up in another community, until or unless the religion is same, the caste, community, tribe will not matter. He will still be Hindu. Understood? That's why I told you, I can teach you family law in a simple way. I can tell you he's Hindu in 4 pages, 2 pages, but your interpretational skills will not be good. The ultimate object of our class is to, give you the proper interpretational skills. Otherwise, it will make no purpose. You can read it from the books also, right? So we need to go bit deep. You read about it, you find out the case laws about it. Okay, we are moving ahead now. So that you have written down, no? These 4 terms are the terms of ejusdem generis, means of the same kind. So to whatever community the next family belongs does not matter. Suppose if the mother was following Shiva, जहाँ वो बच्चा बढ़ रहा है, even if the mother father के हैं उनके maternal parents, grandfather जो हैं उनकी grandmother, even if they have changed the tribe, even if they have changed the community, that will not matter. Till the time the child is being brought up as a Hindu, he will be Hindu, because the objective of the Hindu definition itself is inclusive in nature.
So I had a question.
Yeah.
Sir, if the grandparents were turned to Parsis, let's say, in that case, what would be the religion of the child? He will not be Hindu, of course, but what would be the religion of that particular child? Because he is neither Hindu nor a Muslim nor a Parsi.
No, he will not be. I'll tell you, he will not be Hindu by birth.
Yeah.
Remember this. When I say he's not a Hindu, and when I say he is not a Hindu by birth, there's a difference. He may be Hindu by law. Suppose if he is not converted into Islam, if he is not converted into Jews, if he is not following any other religion, he will still be Hindu. But he will not be Hindu by birth. This is the question. Okay, there is a difference. When I say I'm Hindu by birth, I have to fulfill these two conditions. Why? Because anyone who is not following any religion, anyone who has no religion, he is Hindu by law. Correct? So you should ask me, sir, if he is not following this particular religion, or if they have converted into some Jewish or Parsi or something, whether he still will be Hindu by birth or not. I will say he will not be Hindu by birth, but he will be Hindu by religion, unless or until he has expressly accepted some other religion or converted into some other religion. Because that's why Hindu definition is very wide. Okay? Someone may be Hindu by religion, someone may be Hindu by law, someone may be Hindu by birth. I do not believe in God. आपने देखा होगा किसी के आजकल चल रहा है जो बोलते हैं नहीं नहीं मैं बिलीव नहीं करता भगवान में. मत करो, केस लगेगा, हिंदू लॉ से ट्रीट होना पड़ेगा. सिंपल, बिकॉज यू आर हिंदू बाय लॉ. ओके, और हिंदू बाय बर्थ.
Sir,
Yeah.
excuse me, sir.
Yeah.
Sir, so basically you are saying that if a person is an atheist,
Yeah.
but if his or her parents is a Hindu, so that person, even if he is a atheist, that child is a atheist, Hindu law will be applicable to him.
Yes, yes. See, that's what he will not be Hindu if he has not following any other religion. He will be Hindu. But if he is following some other religion, he will not be Hindu. When one of the parent is Hindu.
Okay, sir. Thank you. Thank you so much.
Write down next point.
Sir, can I ask something?
Yeah, let me just dictate this point. After that, you can ask me this.
Okay,
Next point:
sure.
persons who are not Muslim, Christian, Parsis, or Jews by religion. Write down. जैसे हिंदू बाई बर्थ था वैसे ही हेडिंग डालना. This is a heading. Persons who are not Muslims, Christian, Parsis, or Jews by religion. They are considered as Hindu by law. तो जब आप ये हेडिंग डालेंगे, when you put this heading, persons who are not Muslim, Christian, Parsi, Jews by religion, ब्रैकेट में लिख लीजिएगा Hindu by law. So when anyone is atheist, he is a Hindu, not by religion, not by birth, but by law. It means he is free to practice any religion. He is he's free not to practice anything. But whenever the law whenever the law will apply to him, the Hindu law will be applicable to him, as per the Hindu Act, Hindu Marriage Act. Suppose if the husband and wife both are atheist, the wife wants to file a petition before the court. She will not file a civil suit. Divorce case she wants to file. She will not file a civil suit. She will file a divorce petition under the Hindu Marriage Act. She will take the grounds of Section 13. Okay. Otherwise, her petition will be dismissed. She cannot say in the court that I'm not a Hindu. She may not be Hindu by religion, by birth, but she's a Hindu by law. Okay. Next point is put the heading scheduled tribe. Scheduled tribe. Now write down Article 366, Clause 25. You need to read this article with this particular point. Scheduled tribes. Write down the Hindu Marriage Act or the codified Hindu law provides that its provision do not apply to the member of the scheduled tribes coming within the meaning of Article 366, Clause 25 of the Constitution, unless the central government unless the central government by notification in the official gazette directs that any of the enactments shall apply to them also.
So could you repeat the last line?
Yes, unless the central government by notification in the official gazette directs that any of the enactments, Hindu Marriage Act, Adoption Act, and so on, shall apply to them also. Simple funda ye hai. Article 366 clause 25 provides who are the scheduled tribe and so on. Okay. तो जो भी लोग scheduled tribe हैं इंडिया में, चाहे वो पुडुचेरी में रह रहे हों, चाहे वो डिंडोरी में रह रहे हों एमपी में, चाहे वो बांधवगढ़ एमपी में रह रहे हों, or whether they are living in Kerala, if they are a scheduled tribe, these enactments, Hindu Marriage Act, Adoption Act, Maintenance, and all these acts will not apply to them. So where they will get remedy? This is a problematic thing for them. Suppose in Madhya Pradesh there is an area Bandhavgarh which is a scheduled tribe area. If a wife wants to file a divorce petition, she cannot file under Hindu Marriage Act. She cannot take the grounds of Hindu Marriage Act because custom will govern her. She will file a simple civil suit. She cannot get the benefit of this particular act. So when this act was passed, the objective of it was to protect the customs of the scheduled tribe. But now they only are suffering. They cannot file a case. They cannot take the support of these enactments. They have to file a simple suit, civil suit. They cannot file a divorce petition. She or he cannot file any petition for maintenance. They have to go by the customs. Until or unless central government notifies. Suppose agar central government notify karti hai that these scheduled tribe people of this particular area will come under the ambit of Hindu Marriage Act, then the Hindu Marriage Act or all these acts will apply. Till that time, it will not apply. Even if they are Hindu, it will not apply to them. Okay. So, for example, Tamil. Just a minute. Okay. There is one judgment you write. Last judgment for today. Surajmani, Surajmani, मैं लिख देता हूँ यहाँ पर. I'm writing it down. Surajmani, Stella, Stella versus Durga Charan, AIR 2001, Supreme Court 938. I'm not saying Hindu law will not apply to the scheduled tribe, okay? Remember this. I'm just saying these enactments will not apply to them. Whatever the customs are there, they obviously apply. There are two kinds of Hindu law. There's a codified Hindu law and uncodified Hindu law. Uncodified Hindu law will apply to them, but codified Hindu law will not apply to them. For example, I'll give you, apart from this judgment, there's a, they are known as Tamil Vaniya Christians of Kerala. Tamil Vaniya Christians of Kerala, they are still governed by the Hindu law, uncodified Hindu law, okay? Because they belong to some scheduled tribe. So simple funda is, if someone is scheduled tribe, this act will not apply until unless the central notification is there. But uncodified Hindu law will be applicable to them. Process is they have to file a civil suit. So what was laid down in this judgment? Right down, court held that section 29 subsection 2 of HMA You can read section 29 subsection 2 of Hindu Marriage Act. Nothing contained shall be deemed to affect any right recognized by custom or conferred by any special enactment to obtain the dissolution of Hindu marriage, whether solemnized before or after the commencement of this act. So, section 29 subsection 2 of Hindu Marriage Act recognizes the importance of custom. Comma, it has to be shown that the custom renders the second marriage null and void. I will make you understand why I'm saying so. Mere pleading of the existence of custom stressing monogamy is not enough. The customs have to be proved. Full stop. Thus, no offense under section 494 IPC can be made out.
Sir, can you repeat the section?
Does no offense under section 494 IPC bigamy be made out against the respondent? I will tell you now what were the facts of the case. So write down in this case, husband or a person married to wife the complainant approached the court, the complainant who was a wife approached the court, trial court, and said that she was a scheduled tribe, okay, and said that her marriage was according to Hindu rites and customs. Since the husband has married another woman without giving the first one, without giving divorce to the first one, comma, the husband is guilty under section 494 IPC, which talks about bigamy. Just a minute. Full stop. The wife conceded before the court that the parties are tribals, governed by their customs, She also claimed that the custom in the tribe mandates monogamy as a rule. Mandates monogamy as a rule. The one marriage as a rule. The court dismissed her complaint because she could not prove that particular custom. So court said that the person who is claiming custom she or he has to prove that particular custom कि monogamy है या bigamy है या जितना भी है, polygamy है, जो भी है. So the burden was on her to prove that there was such custom like this of monogamy. So court said, no, you could not prove it. You just made the point, that is it, you could not prove it. So it means that husband is not liable for this bigamy. Court said that it may be allowed. He was acquitted from the charges of 494 IPC. Okay, so for today, I think this much is enough. ज़्यादा लोड लोगे अगर आप लोग तो फिर पता नहीं अगली बार से मिलोगे नहीं मिलोगे. Yes, someone was having doubt. किसी को कोई डाउट नहीं है, समझ आया सबको सब कुछ? एवरीवन हैज अंडरस्टूड द पॉइंट्स. व्हेन यू रिवाइज इट you will get doubts. Come back to me with the doubts, write it in the group, at least tell me one day before. Okay, suppose if the class is on the Saturday, you need to tell me on Friday or Thursday so that I can clarify in a proper way. Okay,
Sir,
baki हाँ, yes.
So just wanted to confirm once just before you go. I missed that part in the question that you gave to us in regards to the section 2, that the party should that the religion should be as of his parents. So what was the answer of that? The child was Hindu or not in regards to that?
The child was Hindu, because I said that those 4 words which is mentioned there, family, community, tribe, and those words, they were in the nature of ageism generis. Okay, ageism generis मतलब होता है same kind, अलग दिए हुए हैं but वो पढ़े same जाएंगे.
Okay sir, okay.
ageism generis ये लिखा हुआ है, मैंने यहाँ पे भूल गया था. Okay, इसके अलावा anything else?
So which group you were talking about? Actually, I'm not added in.
Section 2 explanation B.
No, sorry, sir. What I'm saying is, you were talking about some group that if you have any doubt and ask me in that group. So
Okay,
which group you were talking about?
There is a group, no? All the students are there who are studying family law. What's your name?
No, sir. Hasimuddin, sir.
Okay. You might have messaged me in LinkedIn, I think, just a moment back. I don't know. Or
No,
I may
sir.
have.
I messaged you, I think, yesterday.
तो हो सकता है आपने WhatsApp नंबर नहीं दिया होगा, फिर आपने मोबाइल नंबर दिया होगा.
I mentioned it, sir.
Okay.
Pawan, I'm also not in that group. And
Okay. So if anyone is not there, मुझे डायरेक्ट मैसेज कर दो. I will send you the link. Okay, मेरा नंबर है आप सबके पास में?
Actually not. I don't have.
Sir, if what I'll do is I'll put my number. You send messages. Just send hi. I'll send you the group link. Okay.
Okay.
I'm putting my number here on the group.
Yes, Akshay is putting his number, but take down my number also. Take
Yes.
down my number also if there is any problem. Write down 8447 343516.
And mine is 7795 845630.
Sir, one last question.
Yeah.
So firstly, thank you for conducting this series of for judiciary preparation at Pro Bono. And are we going to get these sessions in regular intervals on daily Saturday, Sunday?
Daily Saturday, Sunday. Every Saturday,
And
Sunday.
timings will be same, no, sir?
Yeah, 2 to 6, because we need to cover the syllabus also. Family law is huge.
Okay,
Okay.
sir, thank you.
After
Yes.
that, we will start some other subject like arbitration or constitutional law or CPC something. We will think about it. Okay, this is
sir,
so
thank
these are the proper classes. These are not. I'm telling everyone. These are not a session कि हमने family law खत्म कर दिया हो गया. We are going to cover everything. Okay, it's like a class, weekends classes.
Oh, sir.
Yeah, Akshay.
So even I received, I think, a few messages that, sir, whether we'll get a certificate for the webinar. So it's not a
No.
webinar. These are the classes, not a webinar.
सर्टिफिकेट नहीं मिलेगा दोस्तों ठीक है मैं कोई रजिस्ट्रेशन
सर्टिफिकेट से बढ़ के नॉलेज मिल रहा है, दैट इज मोर इम्पोर्टेंट.
वही मैं बोल रहा हूँ कि
सर्टिफिकेट इज
these are
जस्ट
the
अ पीस ऑफ पेपर.
yes exactly no one see the people who are the people who are caring about the certificates. First thing, let me tell you frankly, if I recruit anyone, I do not care about certificate. No one in the legal profession cares about your certificates. Literally, when you give your CV, even big firms, they do not ask for your certificates. Litigation में तो कोई फर्क ही नहीं पड़ता है कि आपने अटेंड किया, वो अटेंड किया, किसको फर्क पड़ रहा है आपने, आप लिख दीजिए फैमिली लॉ आपने अटेंड किया. Until unless you know the stuff which is inside it, no one cares about it. और जानने से भी कुछ नहीं होता जब तक आप किसी एडवोकेट का काम करके नहीं दे रहे हो ना. No one cares about it. You have to come in use. You need to ease the work to get the job or something. Anyway, that session is different. We will take some other day. So keep attending the class. Do not miss it. Attend at any cost on every Saturday and Sunday. Otherwise you will miss the link. Once it is missed, everyone will go off. Okay? See you.
Yes, sir.
Thank you.
Thank you, sir.
Thank you so much,
Thank
sir.
you so much, sir.
Thank you, sir.
Thank you, sir.
Sir.
Thank you, sir.